Book 2, Chapter 4, Part 9 of History of the Inquisition of Spain, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. History of the Inquisition of Spain, Volume 1, by Henry Charles Lee. Book 2, Chapter 4, Conflicting Jurisdictions, Part 9. Then the affair suddenly assumed another phase. On March 7th, the Queen had written to her ambassador in Rome to procure the abstention of the Pope from the matter, but on that very day the Congregation of the Inquisition, with the approval of the Pope, had pronounced invalid the censures fulminated by the Inquisitor. It was late in May before this was communicated to the Queen by the nuncio, who said that the Pope had recognized the gravity of the assault by an inquisitor on the episcopal dignity and the magnitude of the ensuing scandal, and had caused the whole subject to be carefully considered by the congregation with the above result. The Pope had felt deeply not only the indignity offered to the episcopal office, but also that the fiscal of the Inquisition had applied to the Queen to summon the bishop before it, solely on the ground of his having appealed to the Holy See. In the name of the Pope, the nuncio therefore asked the Queen to order inquisitors not to proceed against the bishops and to reject the application of the fiscal. Even this did not shake the determination of Nithard to reduce the episcopate to subjection. A long and argumentative consulta was presented to the Queen, proving that the papal decision was surreptitious and therefore invalid, and that anyhow the decrees of the Roman Inquisition had no currency in Spain. The old prohibitions of appeals to Rome were invoked, and the Queen was told that one of the most precious jewels of the Spanish crown was at stake, for unless the regalias were preserved, the Inquisition must disappear, delinquents would be unpunished, religion would suffer, and, with the loss of its unity, there would no longer be obedience to the throne. The Queen was therefore urged to stand firm. The prosecution of the bishop must not be suspended, and the Council of Aragon must be forced to obey the royal commands. Nithard was ready to risk an open breach with the Holy See in his audacious ambition to render the Inquisition supreme in the Spanish Church. How far the Queen would have suffered herself to be carried in the execution of his plans cannot be told, as the documents fail us here. His career, however, was drawing to a close. In February 1669, he was driven from Spain amid universal execration, yet the prosecution of Bishop Manjarre was not abandoned, for the Inquisition was not accustomed openly to admit defeat. It dragged until his death, December 26, 1670, when it was quietly dropped. Practically, the intervention of Rome gave the victory to the Mallorquins, of which they took advantage. In 1671 there arose another quarrel over a fine incurred by a canon who was also a consultor of the tribunal. Both sides exchanged excommunications, and Inquisitor General Valladares, profiting by his predecessor's experience, showed moderation. On the plea that it was a matter of government rather than of jurisdiction, the Suprema ordered the tribunal to abandon the case and remove the censures imposed on the canons. But the latter were not content with this, and procured from the Roman Holy Office a decree declaring invalid the censures of the inquisitors and valid those of the executors of the brief. The Council of Aragon communicated this to the Queen, who submissively signed a letter, January 25, 1672, to the chapter, expressing her confidence that in its use they would pay fitting attention to the peace and advantage of the Church. The Inquisition was not accustomed to defeat, and it chafed under this, as was shown when, in 1690, a quarrel arose because a priest of Minorca, named Juan Ruels, used insulting words to the commissioner, Rafael Pons. For this he was prosecuted, and the case threw all the islands into confusion. The viceroy, the Audiencia, and the clergy all united against the Inquisition. the Ordinary of Minorca, as executor of the brief of 1642, forcibly released Bruels, forbade the inquisitor to proceed, and, on his disobeying, excommunicated him. About this time the Mallorquin tribunal had claims to consideration arising from its vigorous proceedings against Judaizers and the large resultant confiscations. The Suprema espoused its cause with the usual energy and, in repeated consultas to Carlos III, denounced the papal briefs as surreptitious and invalid, full of defects and nullities. The feeble king issued repeated commands for the prosecution of Bruels and the surrender of the briefs, but no one paid attention to them. The Mallorquin clergy procured from the Congregation of the Inquisition a decree validating the censures pronounced by the Ordinary and annulling those of the inquisitor. The Pope confirmed this but subsequently suspended it at the earnest solicitation of the Spanish ambassador, at the same time ordering his nuncio to make the king understand that the Congregation had supreme power to decide all questions of jurisdiction. The affair did not result to the satisfaction of the Inquisition, for the last we hear of it is a bitter complaint by the Suprema, March 11, 1693, of the contumacious Mallorquins and the miserable condition to which they had reduced the Inquisition. In Minorca the clergy and their dependents were so hostile that Pons could not find a church in which to celebrate Mass, while the officials were shunned as excommunicated heretics. Another jurisdiction with which there were occasional quarrels was that of the army, for soldiers were exempt from the secular courts. In such competencias, settlements were made by a junta of 2 members, each of the Suprema and the Council of War, with final reference to the king in case of disagreement. I have happened to meet with but few cases of this, and they seem never to have attained the importance of those with the secular and ecclesiastical courts. One occurred in 1629, arising from disputes with the garrison that had occupied Aljaferia since the troubles of 1591. A somewhat curious case was that of Don Fernando Antonio Herrera Calderon of Santander, who was alguazil and familiar and who resigned in 1641 from his military company, although warned that, by so doing during hostilities, he would be tried by the Council of War. It naturally claimed him and the Suprema endeavored to protect him. It would seem that, towards the end of the 18th century, the exemption of the military was causing special troubles, for a royal cedula of February 9, 1793 declares that, to put an end to them, in future the military judges shall have exclusive cognizance of all cases, civil and criminal, in which soldiers are defendants, except inheritances, and that no tribunal or judge of any kind shall form a competencia concerning them under any pretext. There was yet another independent jurisdiction with which the Inquisition occasionally came into collision. In Spain the military orders formed so important a body that, among the state councils, there was one of orders, which had exclusive jurisdiction over their members. It will be recalled that one of Ferdinand's most efficient measures to ensure the peace of the kingdom was to obtain the perpetual administration of those of Santiago, Calatrava and Alcantara, while the queen assumed that of Montesa. Yet he was not disposed to favor their claims of exemption in temporal matters from the jurisdiction of the Inquisition. A letter of September 15, 1515, to the Tribunal of Jaén says that certain confiscations involve property held by knights of the 3 orders who may claim exemption and refuse to plead before the judge of confiscations. If so, they are not to be listened to and, if necessary, are to be prosecuted with the full rigor of the law. In civil and criminal matters, the members of the orders asserted exemption from the jurisdiction of the Inquisition, leading to disputes more or less acrimonious. In 1609, at Cordova, Don Diego de Argote, a knight of Santiago, with levelled pistol, prevented the arrest of one of his servants by officials of the tribunal. A competencia resulted which, when carried up to Philip III, was decided by him in favor of the Council of Orders. To this the Suprema replied in a consulta: foretelling the entire destruction of the Inquisition in case the decision was allowed to stand, and so worked on Philip that he reversed his decree and allowed the Suprema to prosecute the culprit. The complication caused by these class privileges is illustrated in the case alluded to above, occurring in 1648 at Cuenca of Muñoz de Castilblanque for the murder of the priest Jacinto. He was a knight of Calatrava, which led to an additional competencia when the junta could not agree and the king had to decide. In their contests with the orders, the tribunals were apt to exhibit the same unscrupulous spirit as in those with other contestants. In Majorca, Dr. Ramon Sureda, canon, chancellor, and judge of competencias, was likewise conservator of the military orders. In 1657 he complained that, in conflicts of jurisdiction, the inquisitor would not form competencias with him in order that the papers might take the regular course of transmission for settlement by the Suprema and Council of Orders. The king and queen, therefore, as administrators of the orders, instructed him in such case to send to the inquisitor 3 successive messages and report them and their replies to the council. If, in spite of this, the tribunal continued to prosecute the case, he was to proceed against the inquisitor and the viceroy was to render him all proper support. The inquisitor ingeniously evaded this in the case of Gaspar Puigdorfilio, a knight of Santiago, in 1661, by refusing to receive any messages, saying that he received them only from the viceroy. Sureda's report of this was left unnoticed, and the inquisitor adopted the same device in 1662, in the case of Francisco de Vail, a knight of Montesa, prosecuted for wounding a familiar who had drawn a sword upon him. He refused to receive messages and proceeded to sequestrate various property, including his crops and cattle. To save them from destruction, the viceroy interposed and the Council of Orders appealed to the queen, as administrator of the order, to take some action that should enable such questions to be settled peaceably, but apparently without result. As though the exempted classes were not numerous and troublesome enough, there was a project in 1574 of adding another which, if carried into effect, would have altered the destiny of Spain by subjecting it eventually to the Inquisition and reducing the nominal monarch to the position of a roi fainéant under a mayor of the palace. It is a most impressive illustration of the spirit of the age that such a project should have been formulated, that it received enthusiastic support, and that a sovereign so jealous of his prerogative as Philip II should have even allowed it to be debated, much less have let it assume a menacing shape and have given it serious consideration. A military order was to be established under the name of Santa Maria de la Espada Blanca, with a white sword as a symbol, like the red sword of Santiago. At its head was to be the Inquisitor General, to whom all members were to swear allegiance, and whose orders in peace and war all were to obey. To him likewise they were to assign their property, receiving back at his hands what was necessary for their support, and after death their widows were to be pensioned by him. They were to be exempt from all jurisdiction save his, which was to be delegated to priors appointed in all the provinces. The ostensible object was the defense of the faith and of Spain, for which they were at any time liable to be called to the field or to serve in garrison under the orders of the Inquisitor General. Thus the Inquisition was to be furnished with an organized force, sworn to blind obedience and released from all other obligations. The only requisite for membership was limpieza, or purity of blood, free from all taint of Judaic or Moorish contamination, or descent from those who had been sentenced for heresy. At this period limpieza was becoming a popular mania. The cost of proving it through 4 generations was considerable, and there was strong temptation in the promise that the expenses of all applicants would be defrayed from the common fund. The project may seem to us too wild to merit a thought, but it responded so perfectly to the temper of the time that it was enthusiastically adopted by the provinces of Castile, Leon, Biscay, Navarre, Aragon, Valencia, Catalonia, Asturias, and Galicia. Procurators from these provinces submitted it to Philip for his approval, and were supported by representatives of 48 noble houses and of the archiepiscopal sees of Toledo, Santiago, Seville, Saragossa, Valencia, Tarragona, and Granada. It was debated earnestly and at much length, but the argument of Pedro Vinegas de Cordova decided its fate. He pointed out the troubles which were already arising on the subject of limpieza, causing jealousies, hatreds, and contentions, to be increased enormously if the population was thus to be divided into two classes. Also the fact that the royal courts would have left to their jurisdiction only the New Christians, while the Old Christians would have their special judges, and, if the comparatively few existing familiars caused such all-pervading troubles, what the effect would be of increasing without limit the number of the exempt. On the one hand, the ambitious and able men among the New Christians being thus cast out, would foment disaffection and disturbance. On the other, if the old military orders had been a source of danger to the monarchy, what would be the effect of creating a new one, united and vastly more numerous, and subject as vassals to an inquisitor general, whose power was already so great, and who would control the property and have jurisdiction over all members, while in case of rebellion the frontiers and strongholds would be in his hands? This reasoning was unanswerable. Philip ordered all papers connected with the project to be surrendered. He imposed perpetual silence on its advocates, and wrote to the ecclesiastical and secular bodies to abandon it, for justice and protection would never be lacking. We shall probably do no injustice to the Inquisition in attributing to the profits accruing from the exercise of its temporal jurisdiction the ruthless vigor with which the tribunals sought to vindicate and extend it. The remarks of the Visitor Cervantes with regard to Barcelona, in 1561, indicate how lucrative it could be made, and how welcome was the addition of fees and fines to the somewhat meagre salaries of the officials. This explains the reckless violence which became habitual in the conduct of quarrels, because this not only was an assurance to the parties concerned as to the vigor with which they were defended, but it also served to discourage the secular authorities from resisting encroachments. It also explains the multiplication of the unsalaried officials such as familiars, commissioners and their notaries, assessors, deputies, etc., which no laws or concordias or regulations could restrain, for each one was a possible source of profit to the tribunal and a probable cause of disturbance in his vicinage, through the comfortable assurance of immunity from the law. The natural result of this was that unprofitable business was neglected for profitable, and the suppression of heresy was postponed to the trial of civil and criminal cases which yielded fees. We have seen how Cervantes reported that in Barcelona this seemed to be the real duty of the tribunal, and that there was nothing else to be attended to. His animadversions produced no amendment, and in 1567 de Soto Salazar repeated the complaint. This continued unchecked. The project of reform presented to the Suprema in 1623 expresses the wish that other tribunals would follow the example of Saragossa, where one of the inquisitors was delegated every 4 months to conduct this business, so that prisoners on trial for heresy could have their cases dispatched, and not be kept languishing interminably in prison, which, as we shall see, was one of the sorest abuses inflicted on them. This pious wish was fruitless, and the records of the Inquisition for the following century show how large a portion of its activity was devoted to these cases and to the competencias incessantly springing from them. One feature which aggravated the oppression in these matters, especially in civil suits, was not only the favoritism which inevitably inclined the tribunal to the side of its own people, but the fact that the inquisitors were usually strangers, unfamiliar with the local laws and customs peculiar to each province, which they presumed to interpret and enforce. This justified the frequent demands that inquisitors should be natives, demands which received no attention, for the appointing power thought only of their qualifications as judges of the faith, while to the mass of the population their duties in this respect were of small account in comparison with their activity in their temporal jurisdiction. Another well-grounded source of complaint was that the inquisitorial habits of secrecy could not be wholly overcome. The parties and their counsel were not allowed to be present, as in the royal courts. Witnesses were examined by the inquisitor on lists of interrogatories furnished to him, and there was no cross-examination. Written arguments were presented to him which he handed to the other side for reply, and the procedure in both civil and criminal cases was assimilated as nearly as might be to the secret trials for heresy which was the inquisitorial ideal of the dispensation of justice. The cases were decided by the inquisitors in session together on a majority vote. In the 16th century there was no appeal to the Suprema, even when the vote was not unanimous, but in 1645 a writer assumes that either side could appeal. We have seen how tenaciously the kingdoms of Aragon struggled against the evils of the system. Castile felt them equally, but it had not the same institutions and could only remonstrate. The Cortes of Madrid in 1607–1608 represented that those of 1579 and 1586 had petitioned for the reform of the abuses arising from the temporal jurisdiction of the Inquisition to the great injury of the kingdom, that Philip II had promised relief but had died without granting it, and therefore the request was now repeated in view of the increasing evils. Especially was attention called to the cruelty of imprisoning ordinary offenders, for the people could not distinguish and imagined all prisoners to be heretics, thus entailing infamy upon them and disqualifying them for marriage, wherefore it was asked that they be confined in the public jails. Philip III promised to do what was proper, and of course did nothing. The Cortes of 1611 repeated the petition, with similar lack of result. The Council of Castile, the highest tribunal in the land, in a consulta of 1631, represented forcibly the existing evils, especially the prodigal use of censures under which corregidores and other magistrates lay under excommunication for months together, while individuals were impoverished by the long delays in settling competencias. It urged the remedy of permitting appeals to the council por via de fuerza in cases not of faith, and this it repeated in 1634, 1669, and 1682. More outspoken was a memorial presented in 1648 to Philip by a member of the council on the abuses of the criminal jurisdiction, those in civil cases being treated in a separate paper. The writer alludes to having repeatedly made the same representations orally and in writing. He dwells upon the interminable delays and other obstacles which impede justice and discourage sufferers from seeking it. The resultant immunity creates audacious criminals. The number of familiars and of soldiers who never serve in the field has increased so greatly that nothing is seen but crimes, and the offenders are unpunished. Everywhere men of the most dissolute type and the largest fortunes seek appointment so as to enjoy immunity. The royal revenues are defrauded and prohibited goods are imported, while no corregidor or alcalde dares to curb them, for they are at once excommunicated by the inquisitors, even to casting interdicts over whole communities. Those who suffer remain without redress, so that those who are able are led to take it into their own hands, for they can get it nowhere else. Justice is trampled underfoot. There is no alguazil who dares to make an arrest, or scrivener to draw up papers, so many have been slain or wounded for so doing, and the death of an alguazil is held at naught, as though the officers of justice were common enemies. If the king would re-establish the jurisdiction of the royal courts, there would be an end to the excommunications with which the inquisitors defend their delinquents, as though they were vessels of the temple. The time of the councils and of the king would not be consumed by these perpetual competencias, and the plagues would cease, wherewith God afflicts these kingdoms for the injustice, the violence, and the dissolute life of the people. These warnings and remonstrances fell on deaf ears. The Suprema was skilled to work upon the piety of the king, and to promise him relief from perils if he would placate God by increasing the privileges of the Inquisition, the very existence of which depended upon its ability to protect its familiars from the law and from the universal hatred in which they were held. End of Book 2, Chapter 4, Part 9. Recording by Shena Sayre, Fresno, California.
Book 2, Chapter 4, Part 10 of History of the Inquisition of Spain, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Algie Pug, Perth, Western Australia. History of the Inquisition of Spain, Volume 1, by Henry Charles Lay. Book 2, Chapter 4, Conflicting Jurisdictions, Part 10. After the fall of Inquisitor General Nithard, there was a bustling attempt to check the enormous evils admitted to exist. In 1677, Carlos II deprecated the abuses common both in excessive charges and in forcing his pious subjects to submit by censures which deprived them of the consolations of religion. He declared excommunication to be illegal in matters connected exclusively with laymen and temporal possessions, and forbade its employment, a command which he addressed to the Suprema in 1678 with directions to enforce it, and which he repeated in 1691, but without effect. Then a more comprehensive effort was made to effect a radical reform. In 1696, Carlos was induced to assemble what was known as the Junta Magna, consisting of 2 members each of the Councils of State, of Aragon, of Castile, of Italy, of Indies, and of Orders. The decree creating it recites the disturbance and the interference with justice, the continual collisions and competencias between the Inquisition and the courts over question of jurisdiction and privileges, and the necessity of establishing some fixed principles and rules to avert these troubles for the future, and to preserve the Holy Office in the love and reverence of the people, without its interfering in matters foreign to its venerable purpose. The junta was to meet at least once a week, and it was furnished with materials from the records of all the councils, through which it obtained a thorough insight into the evils to be remedied. These labours resulted in a memorial known as the Consulta Magna, drawn up by Dr. Joseph de Ledesma of the Council of Castile. It constituted a terrible indictment of the abuse, by the Inquisition, of the temporal jurisdiction bestowed on it by the sovereigns, with ample proof of flagrant cases and incidents. Then followed a consideration of possible remedies, of which the most indispensable was declared to be the prohibition of censures, which were so formidable that no one could resist them. Persons arrested for offences not of faith should be confined in the royal prisons to save them from the indelible disgrace of the secret prison. The recurso de fuerza should be admitted when excommunication was used in temporal cases. The fuero should be withdrawn from the servants and commensals of officials whose insolence gave occasion to arrests and censures causing dissensions that scandalized the whole kingdom. It was admitted that familiars now gave little trouble, save in Majorca, where there was no concordia, but the salaried officials were the source of infinite contention, and they should be put on the footing of familiars. A grievance of the greatest magnitude was the interminable delay in the settlement of competencias, during which prisoners languished in confinement and excommunicates could not obtain absolution. This could be averted if the concordias and royal orders were enforced. As all attempts to curb the Inquisition had proved useless, and in spite of them it had continually increased its abuses, the ultimate remedy of depriving it wholly of the royal jurisdiction might be found necessary. But meanwhile these milder measures might be tried in hope of relief. These proposed remedies, it will be seen, were moderate enough, and in no way limited the Inquisition in its ostensible functions as a preserver of the faith. This was the most formidable assault that the Inquisition had experienced, coming as it did from the combined forces of all the other organizations of the state under the auspices of the king, but it was easily averted. Llorente tells us that Inquisitor General Rocaberti, working through the royal confessor Froilan Diaz, who was ex officio a member of the Suprema and also Rocaberti's subject in the Dominican order, succeeded in inducing Carlos to consign the consulta to the limbo in which reposed so many previous memorials. The manner in which this was effected was simple enough. In 1726, Don Santiago Agustin Riol drew up for Philip V a report on the creation and organization of the state councils, in which he states that the consulta was submitted to the Council of Castile for its action. This was delayed by the illness of the governor of the council. When he returned to duty, the matter was forgotten, and the consulta disappeared so completely that when Philip V called for it in 1701, no copy could be found in the archives, as appeared from a certificate furnished by the archivist. This narrow escape did not teach moderation. In 1702, the Valencia tribunal refused even to join in a competencia over a case in which it entertained a suit brought to collect the interest on a censo by the widow of an alguazil mayor as guardian of her children. It was in vain that the regent of the Audiencia pointed out that under the Concordia of 1568 the widow of an official only enjoyed the fuero as defendant and not as plaintiff, and that the children had no claim whatever, and cited precedents that had been so decided. The tribunal was stubborn and would not even admit that the question could be carried up to the Suprema and Council of Aragon for decision. It was not long after this, however, that the Suprema was obliged to admit that reforms in the methods of the Holy Office were essential. In its Carta Acordata of June 27, 1705, is embodied a rebuke of the recklessness with which the tribunals undertook the defence of their officials, resulting in the universal complaints of the abuse of its jurisdiction, so that it was popularly said that everything was made a caso de inquisición, to the disrepute of its officials and their families. Therefore, unless the jurisdiction was indisputable, the Suprema must be consulted before assuming the defence. Amicable adjustments must also always be sought, and friendly relations be maintained with the royal officials, thus avoiding competencias which ordinarily arose from passionate conflicts over trifles. These were wise admonitions, to which, as usual, scant attention was paid, but in time the tribunals were made to recognize the change that had come in with the Bourbons. There was a highly illustrative case in 1720 at Toledo, where Don Pedro Panagua, contador or auditor of the tribunal, received in October 20 sacks of cocoa from Cadiz. In the intricate details of the Spanish system of internal imposts, it will be impossible now to say whether he had observed the formalities requisite in the transmission of merchandise, but the local authorities assumed that there was a violation of law, and also an infraction of quarantine, imposed in August, owing to an epidemic in Marseille. The corregidor was prompt. At 2 a.m. of the day following the arrival of the cocoa, he searched Panigua's country house, and at 9 a.m. his town house, and sequestrated the cocoa. The inquisitors responded by imprisoning the civic guards who had been employed. A fortnight later, another visit paid to Panigua's house showed that 5 sacks of the sequestrated article had been removed, whereupon he was confined in the royal prison. Then the inquisitors proceeded against the corregidor and alcalde mayor with censures, and aggravated them so energetically that in 24 hours they had an interdict and a cessatio a divinis in 4 parishes of the city. These active demonstrations, however suited to the 17th century, were out of place in the 18th. As soon as news of them reached Madrid, hurried orders were dispatched by the Suprema to remove the interdict, absolve the officials and release the guards, and when the formal report came from the tribunal the orders were repeated, with the addition that the senior inquisitor should start for Madrid within 24 hours. Prior to receiving this the inquisitors had written to Inquisitor General Camargo, lamenting his abandonment of them and the dishonour inflicted on the tribunal. They blushed to be accomplices in this ruin, and they tendered their resignations. The answer to this was sending the senior inquisitor of Madrid to take charge of the tribunal, with orders to the 2 remaining inquisitors to remain in Madrid, but on learning that they had obeyed the first orders, they were allowed to remain in Toledo. How strong had been the pressure exerted on the Suprema to produce this action may be inferred from a protest in which, a month later, it poured forth to Philip V its bitterness of soul. The corregidor had violated the privileges and immunities of the Inquisition. The inquisitors had been perfectly justified in their action, although too speedy in aggravating the censures. They had been humiliated, while the corregidor and his underlings were boasting of their triumph over the Inquisition and of depriving it of the rights granted by the popes and the kings of Spain. The Suprema therefore asked that the senior inquisitor be allowed to return to Toledo, that Panagua be released by the hands of the inquisitors, that his cocoa be restored, and that the corregidor and alcalde mayor be duly punished. This accomplished nothing, and 2 months later it again appealed to the king for the release of Panagua and the restoration of the senior inquisitor, but this time it professed its zeal to see that in future the tribunals should practice more moderation. The lesson was a hard one, but it had a still harder one in 1734, when Philip decided that a salaried official should be tried by the ordinary courts. Step by step the old-time privileges were being curtailed. Soon after the accession of Fernando VI, some trouble rose at Llerena over the taxation of familiars. It seems to have been aggravated in the usual manner, and when it reached the king, it was of a character that induced him to issue a decree, October 5, 1747, by which the Council of Castile was given jurisdiction over the officials of the Inquisition. This called forth a heated remonstrance, dated November 1, which must have proceeded from the Inquisitor General Prado y Cuesta, for no other subject would have dared thus to address his sovereign. The writer tells him that the decree is unworthy of his name and his faith, nor is it well that the world should see him, in the first year of his reign, discharge such a thunderbolt against the Holy Office, such as it had never received since its foundation, leaving it prostrated by the shock. He affirms before God, and would wish to write it with his blood, that the service of Jesus Christ and the prosperity of the king and his kingdoms require that the decree be returned to the royal hands, without a copy being allowed to remain. Although this decree was not effective as to the salaried officials, the Inquisition was falling upon evil days. It no longer inspired the old-time awe. It was no longer striving to extend its prerogatives, but was fighting a losing battle to maintain them. A writer of about this period deplores its decadence. Its commissioners and familiars serve without pay, and the only reward for their labours and the cost of making their proofs of limpieza is the exemptions of pure honour granted by the kings. But now scarce one of these is observed, and no fit persons seek the positions, although they are much needed, for there are not a 10th part of those allowed by the Concordias. There is probably some truth in this, for Inquisitor General Prado y Cuesta, in appointing, at the request of the Tribunal of Valencia, Fray Vicente Latorre as calificador or censor, asks why, when there are so many learned canons and professors in Valencia, who formerly were eager in seeking the position, it had now fallen so greatly in estimation. It was difficult for the Inquisition to reconcile itself to the tendencies of the age, and several cases, about this time, in which the Tribunal of Valencia refused even to admit competencias, asserting that its combined ecclesiastical arid royal jurisdictions rendered it the sole judge of all that concerned its officials, show that the old spirit still lingered and found expression whenever it dared. Carlos III, however, was even more assertive of the royal prerogative than his brother Fernando. We have seen his orders of 1763 concerning municipal and police regulations, which include the prohibitions of carrying concealed weapons and exporting money, in all of which familiars were wholly removed from the jurisdiction of the Inquisition, and in 1775 a competencia in Cordova caused him emphatically to order the inviolable observance of this decree. All this led to the change in the commissions of familiars as regards carrying arms, which was brought about in 1777 by the authorities of Alcalá la Real and Seville refusing to register commissions issued by the tribunals of Toledo and Seville because they were not in accordance with the new regulations. In place, as of old, of blustering and coercing the magistrates, the Suprema collected from all the tribunals the formulas employed by them and framed a new one, phrased in a very different spirit and in accordance with the royal edicts. That the endless quarrels which we have been considering ought to be settled in an amicable manner was so self-evident that, from an early period, persistent efforts had been made to accomplish it, resulting in the competencia so frequently alluded to above. Originally it would seem that there was no established procedure, and that the Inquisition settled for itself all questions arising with the magistrates. After the first opposition had been broken down, these were not numerous, until the attribution of fuero to the officials, and the enormous multiplication of familiars and other unsalaried officers gave occasion for collisions with the courts. The earliest attempt that I have met to prove a method of settlement is the cedula issued about 1535 by the Empress Regent in the absence of Charles V, ordering that when there was a dispute about jurisdiction, the President and judges of the royal court should meet the inquisitors and arrange matters harmoniously, so that it should not be known that there had been a difference between them. It was in conformity with this that, in 1542, when Joaquin de Tuenes was tried in Barcelona for the murder of Juan Bayel, a familiar, the inquisitor Miguel Puig held a conference with the regent and judges of the royal chancellery prior to the arrest, and the custody of the accused was settled without difficulty. It was impossible, however, to preserve peace between classes mutually jealous, and we have seen the troubles which Prince Philip endeavoured to settle by the cedula of May 15th, 1545. This favoured the royal jurisdiction, and produced complaints from the Suprema, as when, in 1548, it represented to Charles V that in Granada the judges had made the cedula a pretext to intervene in the business of the tribunal whenever one made a complaint, requiring the inquisitors to interrupt their work and come to the audiencia, where they were ordered not to proceed, and if this were disobeyed, the judges raised a great disturbance. All this would cease if the old rule were restored, that any one feeling aggrieved must appeal to the Suprema, where he would get justice. Prince Philip's cedula of 1553 settled this as far as concerned matters of faith, but neither it nor the Castilian Concordia of the same year could prevent disputes over the immunities of the officials and familiars which the Inquisition was persistently endeavouring to extend. The Concordia, however, endeavoured to provide for the settlement of these by the process described above, which became technically known as competencia. It is remarkable that, in the Valencia Concordia of 1554, there is no such provision, but in that of 1568, for the Aragonese kingdoms, it appears in a slightly different form, that the regent of the audiencia and the senior inquisitor should consult and endeavour to come to some agreement. If they could not do so, the regent was to send his side of the case to the Council of Aragon, and the inquisitor his to the Suprema, when the king would arrange how the matter should be decided. The two formulas were combined in practice, and remained the established method of settling conflicts of jurisdiction. This should have produced peace, but we have seen that it only gave occasion for fresh subjects of discord. The inquisitors were restive under any restraint on their arbitrary methods, and already in 1560 a Carta Acordata of November 14th warns them that they are not to proceed with censures against the judges when the latter offer competencias, but are to send the papers to the Suprema and await the result, under a penalty of 20 ducats for every infraction of the rule. The inquisitors, however, avoided competencias as far as they could, and when obliged to concede them, the opportunity was taken of humiliating the royal judges and make them feel their inferiority in a manner most galling to men so tenacious of the respect due to position and so insistent on courtesy. When de Soto Salazar reports to the inquisitors of Barcelona that, when they had occasion to notify the lieutenant of the king or regent of the audiencia, they sent a message to summon him, and then kept him waiting in the antechamber, and that sometimes they called the judges before them and scolded them without cause, we can readily appreciate the intensity of their hatred thus excited. So, when the Inquisition established its formula for competencias, they were sedulously framed to be as arrogantly insulting as possible. The first mandate inhibits peremptorily the judge from action, and orders him to remit the case to the tribunal within 24 hours. If an arrest had been made, the prisoner is to be discharged on bail to present himself before the inquisitors, and any property seized or sequestrated is to be released. If the secular judge has any reason to allege to the contrary, he is to present himself in person or by procurator to the tribunal, which will render justice, and all this is under holy obedience and the threat of major excommunication and a heavy fine. If there are any papers in the case, the scrivener is ordered to surrender them, and the accuser or plaintiff is to appear within a time specified and receive justice, in default of which the case will be heard without him and without further notice. Then, if a reply is made to this alleging reasons for not obeying, a second mandate is issued pronouncing them insufficient and ordering the first one to be obeyed within a specified time under the above penalties. If the judge then proposes the competencia, a mandate is sent to him reciting the previous ones and saying that to avoid troubling the higher powers, he is ordered to surrender all papers and suspend all action, or the excommunication and fine will be enforced on his person and property. The next mandate accepts the competencia, states that the tribunal is ready to forward its papers and orders the judges to send their side within 12 days, adding a threat of excommunication and fine if any additional testimony be taken in the case. All this is phrased in the most mandatory fashion as of a superior addressing a subordinate, and all these missives are ordered to be returned to the tribunal. If, after a competencia was formed, the familiar or official accepted the jurisdiction of the secular court, he was deprived of his commission. As we have frequently seen, there was no hesitation at any stage of the proceedings to excommunicate the judges, to anathematize them, and to lay an interdict on the city, followed by cessatio a divinis. In addition to the gratification of thus humiliating the magistrates, there was also in this truculence the object of rendering the process so offensive as to make them shrink from resisting the encroachments of the Inquisition. When this failed, the tribunal had abundant sources of annoyance in raising interminable questions of precedents and formalities, which were sometimes fought so bitterly and long as to virtually to supersede the original case. The points that could be raised were endless. In 1602, the Count of Benavente, then Viceroy of Valencia, issued letters ordering a conference over the arrest of Geronimo Falcon. The tribunal surrendered him, admitting that the case did not pertain to it, but demanded that the Viceroy and Chancellery should cancel the letters on their records, and on refusal it excommunicated the regent. The matter was carried up to the Suprema and Council of Aragon, when the king decided that the letters must be expunged, and it was done in the presence of the Secretary of the Inquisition. The same humiliation had been inflicted on the Count's father, when he was Viceroy, and also on the Duke of Segorbe. This arrogance continued until Carlos III, in his decree of 1775, informed the Inquisition that the royal jurisdiction which it exercised was on precisely the same level as that of his judges and magistrates. There must be entire equality between them. All threats of communication and fines must be abandoned. There must be free interchange of papers, mutual courtesy, and no assumption of superiority. It was difficult for the tribunals to abandon the formulas which flattered their vanity, and a second command was necessary, issued in 1783 on the occasion of a prolonged conflict of the Valencia tribunal with the alcalde of Constantine. This finally produced obedience, and the Suprema transmitted the royal order to Valencia with instructions for its observance. End of Book 2, Chapter 4, Part 10. Recording by Algie Pug.
Book 2, Chapter 4, Part 11 of History of the Inquisition of Spain, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. History of the Inquisition of Spain, Volume 1, by Henry Charles Lee. Book 2, Chapter 4, Conflicting Jurisdictions, Part 11. While this doubtless diminished the exasperation of these conflicts, it did not check their frequency. They continued to be a constant source of trouble, and it was from a desire to diminish this as well to extend its authority that the Suprema, in 1806, forbade the tribunals from instituting them without submitting the case to it and receiving its approval. When, under the Restoration, the Inquisition was revived in 1814, the officials naturally claimed the fuero, active and passive, civil and criminal, and Fernando VII, in the decision of a case carried up to him from Seville, announced February 15, 1815, in no uncertain tones, that they should be protected in its enjoyment, but the cases appear to be rare, and the aggressive spirit had disappeared. When in Seville the creditors of Francisco de Paula Esquivol complained of him to the tribunal, in place of defending him it promptly dismissed him, June 27, 1815, an action which was confirmed by the Suprema. Even more significant was a case in 1816, when in Seville Lorenzo Ayllon abused a priest while celebrating Mass, and endeavored to seize the sacrament, and the secular authorities arrested and proceeded to try him. In such a case there could be no question as to the jurisdiction of the Inquisition, but there was no disturbance, and when the tribunal claimed his transfer to the secret prison, the Suprema interposed and ordered that he should be allowed to remain in the public jail, a detainer being lodged to prevent his discharge during his trial, a concession to the royal jurisdiction which would have petrified Pacheco or Arce y Reynoso. There was the same disposition to avoid coming to extremes with the spiritual courts. In 1816 the provisor of the see of Tuy prosecuted Joseph Metzger for impious, execrable and sacrilegious blasphemies. The tribunal of Santiago applied, in a courteous note, to the provisor for the papers, and received a reply without signature. This the Suprema directed it to return and explain that there was no desire to invade the episcopal jurisdiction, but as the blasphemous propositions and acts of Metzger might be heretical, of which the Inquisition had exclusive cognizance, it must insist on seeing the evidence to extract what appertained to it, after which the papers would be returned. It seems to have obtained the evidence, for on October 15, 1817, it voted to imprison Metzger as soon as his trial by the provisor should be ended, but the Suprema instructed it not to wait for this, as the jurisdiction of the Inquisition was privileged. There was one peculiarly irritating feature in the position of the Inquisition in these quarrels, which exacerbated them greatly, and often neutralized all efforts to maintain harmony: the power which it arrogated to itself of refusing to form competencias on the ground that its rights were too clear to admit of debate. Thus it held that the salaried and titular officers, with their families and servants, were so wholly beyond all secular jurisdiction that it refused to entertain any proceedings in contest of their claims. It was in vain that Philip III, by a royal letter of 1615, declared that if inquisitors refused a conference, on the ground that the matter was too clear to justify it, the regent of the chancellery should form a competencia and forward the papers as usual. It was equally useless for Philip IV to decree in 1630 that when a contention was started by either party, the other must entertain it, no matter how clear it might be, under pain, for a first offence, of 500 ducats, and for a second, of suspension during the royal pleasure. To ensure the imposition of the fine, each council was to give the other faculties for its collection from offenders, but when the Suprema forwarded this decree to the tribunals, with orders for its strict observance, it added significantly that it did not apply to cases of salaried and titular officials, though no such exception was made in the decree. It knew that Philip would never summon courage to enforce his law, and it was right. When, in 1633, the Council of Aragon endeavored to collect such a fine, the Suprema interposed, asserting that it could only be done by consent of both councils, which was in effect to invalidate the law, and Philip himself violated it in 1634, when Agustin Vidal, messenger of the Tribunal of Valencia, was arrested by the royal court for the murder of Juan Alonso Martinez, a knight of Santiago and baile of Alicante. The tribunal demanded him and refused a competencia, when Philip weakly ordered him to be surrendered, for this time and without prejudice to my royal jurisdiction. The Inquisition carried its point. Philip, by decisions of 1645 and 1658, admitted that there could be no competencias in the case of salaried officials, and the Suprema enforced these decisions by a Carta Acordada of August 7, 1662, pointing out that they must not be entertained where such officials were concerned. At the same time, the tribunals were warned to exercise moderation and not to employ censures without consulting it, unless delay was inadmissible. Even Philip, however, had to intervene against the consequences of his own acts in 1664, when the portero of the tribunal of Logroño killed in his house a priest, apparently through jealousy. The alcalde mayor prosecuted the murderer and arrested his wife. The tribunal excommunicated the alcalde and cast an interdict on the town. The Council of Aragon formed a competencia and claimed that during it the censures should be raised according to custom, but the Suprema refused on the ground that there could be no competencia. Philip was appealed to and ordered the censures raised for the unanswerable reason that as judges under excommunication could not hold their courts, if it were allowed thus to paralyze all judicial business, it would have arbitrary control over all cases and frustrate all legal remedies. This decision was disregarded. It seems extraordinary that any community would endure for centuries the indefinite stoppage of the administration of justice, constantly occurring through the reckless abuse of the power of excommunication, as when, in 1672, we find the Queen Regent applying to the Inquisitor General to know how she is to answer the complaints of the town of Logroño at the prolonged suspension of the powers of the corregidor who lay under excommunication, seeing that there is no conclusion of the competencia which has been so long pending. The Inquisition evidently aggravated as far as it could the public distress as a means of establishing its claims. In an effort to limit the abuse of refusing competencias, there was a junta formed in 1679 from the Suprema and Council of State with the assistance of some theologians. This admitted that there could be no competencia in the cases of salaried officials, except when they held public office and were prosecuted for malfeasance, but it laid down the rule that, when the Suprema refused a competencia, the Council of State could appeal to the king, who could appoint a junta to decide this secondary question. Unlimited time was allowed to the Suprema to state its reasons for refusal, and during a competencia the accused was to be liberated on bail, and all censures were to be raised. This removed some of the hardships, but the Suprema seems to have sought to evade it by sullenly refusing to form the juntas with the royal councils, for another decree of Carlos II ordered it to attend when summoned so that these affairs might be settled. It was in vain that, in 1730, the Council of Castile urged that competencias be admitted in all cases, for Philip V decided that the agreement of 1679 should stand. Probably not much was gained in the latest attempt to settle these perennial quarrels by Carlos IV in 1804, who ordered that when a conflict arose between a royal court and a tribunal, in a matter not of faith concerning an official, the court should refer the case to the governor of the royal council, and the tribunal to the Suprema. These should then select an examiner who was to report to the Secretaria de Gracia y Justicia for the royal decision. The evils of the system were admitted on all hands, but it was so vicious in principle that remedies were impossible. The customary juntas of 2 members each from the Suprema and the Council of Castile or of Aragon was at best a clumsy device, onerous on the councils and usually leading only to procrastination. To systematize it, in 1625, a permanent Junta Grande de Competencias was formed, of 2 members from each council, whose duty it should be to dispatch all cases, and rules for it were framed in April 1626, but it was short-lived. In 1634, Philip IV ordered the formation of a junta of 2 members each of the Suprema and Council of Castile to formulate a plan of relief, but on June 9th of that year the Suprema reported that it had never been able to accomplish a meeting of the junta. Then, in 1657, the Junta Grande was resuscitated, and we meet with an allusion to it in 1659, but it appears to have been abandoned soon afterwards. Ingenuity was at fault to alleviate the evils inseparable from the permanent antagonism between the rival jurisdictions. Of these evils, the one most keenly felt was the interminable delay in the settlement of cases. The councils from which the members were drawn were crowded with their more legitimate business. There was rarely accord in the junta. The matter would be argued without exception of agreement. Each side would be obstinate. Perhaps the case would be referred to the king, or years would pass before a settlement would be reached. Perhaps, indeed, it would be silently dropped without a decision, especially when a decision might be undesirable because one or both sides feared a troublesome precedent. Meanwhile, the case remained petrified in the condition existing at the time the competencia was formed. Until the so-called Concordia of 1679 permitted the release of prisoners on bail, if anyone had been arrested, he remained in prison, perhaps to die there, as sometimes occurred. In 1638 the Inquisition complained of this when its officers happened to be the prisoners, for competencias were always slow of settlement, and the work of the tribunals was crippled for lack of their ministers, while their poverty precluded their giving adequate salaries to substitutes. It was not until 1721 that a remedy for this procrastination was sought by Philip V in a decree reciting the long delays and frequency of cases remaining undecided by reason of a deadlock in the junta, wherefore in future when a junta was formed he was to be notified in order that he might appoint a 5th member, thus assuring a majority. It does not seem, however, that this accomplished its purpose, and when Carlos III consolidated the cumbrous framework of government by instituting the Junta de Estado, composed of the ministers of the several departments, Florida Blanca enumerates, among the benefits accruing, the expediting of cases of competencia and avoiding the interminable delays caused by the etiquette of the tribunals and the intrigues of the parties concerned. I have dwelt thus in detail on this subject, not only because it absorbed so large a portion of the activity of the Inquisition, but because of its importance and relations between the Holy Office and the other institutions of Spain, and in explaining the detestation which the Inquisition excited. If the people regarded it as a whole with awe and veneration, as the bulwark of the Catholic faith, their hatred was none the less for its members, and the perpetual struggle against the tremendous odds of its power, supported by the unflinching favor of the Habsburgs, bears equal testimony to the tenacity of the Spanish character and to the magnitude of the evils with which the Inquisition afflicted the nation. End of Book 2, Chapter 4, Part 11. Recording by Margaret Espaillat, Orlando, Florida. Book 2, Chapter 5, Part 1 of History of the Inquisition of Spain, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. History of the Inquisition of Spain, Volume 1 by Henry Charles Lee, Book 2, Chapter 5, C, Part 1. The preceding chapters illustrate some of the causes that provoked popular hatred of the Inquisition, but these were by no means all. It enjoyed, as we have said, enthusiastic support in the exercise of its appropriate functions in defending the faith, but apart from this it had infinite ways of exciting hostility. This was the inevitable result of entrusting irresponsible power to men, for the most part overbearing and arrogant, who owed obedience only to the Suprema and who early learned that, while it might disapprove of their acts, it always supported them against complaints, and, while it might administer rebuke in secret, it hesitated long before it would compromise the asserted infallibility of the Holy Office by dismissal or any other public demonstration. There was no other power to call them to account, and they could rely upon its indulgence. This indulgence they extended to their subordinates, over whom, indeed, they had not the power of removal, and the consequence was that the whole body thoroughly earned the detestation of the people by the abuse of their privileges, creating irritation which was none the less exasperating because its causes might be trivial. The situation finds expression in a Carta Acordada of October 12, 1561, in which the Suprema begs the tribunals, for the love of God, to inflict no wrong or oppression for, since they are accused when they do right, what is to be expected when they give just grounds of complaint. Whether just or not, grounds of complaint were never lacking. The power of the inquisitor had practically scarce any bounds but his own discretion, and the temptation to its abuse was irresistible to the kind of men who mostly filled the position. In the memorial of Llerena to Philip and Juana in 1506, complaint is made that the officials seized all the houses that they wanted, and in one case, when some young orphan girls did not vacate as quickly as ordered, they fastened up the street door and the occupants were obliged to make an opening in order to leave it. The same spirit was shown to parties not quite so defenseless in 1642, when its exhibition in Cordova nearly provoked a disastrous tumult. There was a vacant house which Juan de Ribera, one of the inquisitors, talked of renting, but he went to Murcia without taking it. On his return he found it had been leased to a son of Don Pedro de Cardenas, one of the veinticuatros, or town councillors. He sent for Cardenas and asked whether he knew that he had engaged the house. Cardenas professed ignorance, adding that if he had not moved his family into it he would abandon it. Ribera ordered him to leave it, and on his refusal, the tribunal took up the quarrel by serving on him a notice to quit. As he did not obey, it cited him to appear and forced him to give security. His kinsmen and friends rallied round him and promised to sustain him by force. The matter became town talk, and the tribunal felt its honor engaged to sustain its commands by violence. It assembled the 2 companies of soldiers which it kept in the Alcazar, while the caballeros armed themselves and guarded the house. The corregidor appealed to the tribunal not to drench the city in blood by posing the poor civic militia to the swords of the gentlemen, and it consented to carry the matter to the king. The Council of Castile ordered that the tenant be maintained in possession, while the Suprema instructed the tribunal not to yield a jot, but to eject him by whatever means it could. What was the outcome does not appear, but the case illustrates the extent to which the Inquisition magnified its powers and the determination with which it employed them. It was impossible to prevent these lawless abuses. The Suprema might scold and threaten, but, as it rarely punished and always protected the offenders, its restraining efforts amounted to little. The visitadores, or inspectors, duly reported disorders, and instructions would be issued to reform them, but to these the inquisitors paid little respect. There is no reason to suppose that the Barcelona tribunal was worse than any other, and a series of reports of visitations there gives us an insight into the evils inflicted on the people. In 1544, Dr. Alonso Perez sent in a report in consequence of which the Suprema roundly rebuked all the subordinates, except the judge of confiscations. All but 2 were defamed for improper relations with women, all accepted presents, all made extra and illegal charges, all neglected their duties, and most of them quarreled with each other. The fiscal was especially objectionable for his improper conduct of prosecutions and for appropriating articles belonging to the tribunal. He refused to pay his debts. He arrested a candlemaker for not furnishing candles as promptly as he demanded. When a certain party bought some sheep from a peasant and was dissatisfied with his bargain, the fiscal cited the peasant, asserted that the purchase money was his, and forced the peasant to take back the sheep and return the money. Yet the Suprema was too tender of the honor of the Holy Office to dismiss a single one of the peccant officials. It ordered them to be severely reprimanded, a few debts to be paid, and presents to be returned, and uttered some vague threats of what it would do if they continued in their evil courses. The natural result of this indulgence appears in the next visitation by the Licenciado Vaca in 1549. The same abuses were flourishing, with the addition that the inquisitor, Diego de Sarmiento, had accepted the position of the commissioner of the Cruzada indulgence and had appointed as its preachers and collectors the commissioners and familiars of the tribunal, to the great oppression and vexation of the people, whose dread of the Holy Office prevented complaints. Sarmiento was dismissed in 1550, but in 1552 he was reappointed to Barcelona. The fiscal and notary who were specially inculpated were suspended for 6 months, and the jailer, for ill treatment of prisoners, was mulcted in 1 month's wages. In 1561 another visitation was made by Inquisitor Gaspar Cervantes, whose report was exceedingly severe on the disorders of the tribunal and drew from the Suprema an energetic demand for their reform. This produced no amendment. The tribunal went on undisturbed until the complaints of the Cortes of 1564 led to another and more searching investigation by de Soto Salazar in 1566. There were not only abuses of all kinds in the trials of heresy, but numerous cases in which, as the Suprema told them, they had no jurisdiction. Apparently, they were ready to put their unlimited powers at the disposal of all comers, and imprisoned, fined, and punished in the most arbitrary manner, gathering fees, commissions, and doubtless bribes, and selling injustice to all who wanted it, while the dread of their censures prevented opposition or remonstrance. In these cases, which were not of faith, the accused were often seized in the churches, where they had sought asylum, and the repeated instances in which the Suprema orders their names stricken from the records points to one of the most cruel results of this reckless abuse of jurisdiction, for it inflicted on the sufferer, his kindred and posterity, an infamy unendurable to the Spaniard of the period. The long and detailed missive which the Suprema addressed to the tribunal as the result of Salazar's report gives a most vivid inside view of the abuses naturally springing from unrestrained autocracy, which, by the absolute and impenetrable secrecy of its operations, was relieved from all responsibility to its victims or to public opinion. The Suprema takes every official in turn, from inquisitors down to messengers, specifies their misdeeds and scores them mercilessly, showing that the whole organization was solely intent on making dishonest gains, on magnifying its privileges, and on tyrannizing over the community, while the defense of the faith was the baldest pretext for the gratification of greed and evil passions. Yet all this was practically regarded as quite compatible with the duties of the Inquisition. The 3 inquisitors, Padilla, Zurita, and Mejia, were suspended for 3 years and were then sent to repeat their misdeeds elsewhere, and the 2 former were in addition fined 10 ducats apiece. That an institution possessing these powers and exercising them in such fashion should be regarded with terror and detestation was inevitable. We shall see hereafter how it shrouded all its acts in inviolable secrecy, and how it rightly regarded this as one of the most important factors of its influence, and we can understand the mysterious dread which this inspired, while at the same time it released the inquisitor and his subordinates from the wholesome restraint of publicity. The smothered hostility thus excited was always ready for an explosion when opportunity offered to gratify it. In the desire to stimulate the breeding of horses, a royal pragmatica in 1628 prohibited the use of mules for coaches. The inquisitors of Logroño, in the full confidence that no one would venture to interfere with them, persisted in driving with mules, and when the corregidor, Don Francisco Bazan, remonstrated and threatened to seize a coach, they told him it would be his ruin. He did not venture, but in 1633 he procured from the Council of Castile an order that no coaches should be used in Logroño, under pretext that they damaged certain shops projecting on the principal street. The fiscal of the tribunal undertook to meet this by asserting that it had a special privilege from the king concerning coaches, but when Bazan promised to obey, it was not forthcoming. The Suprema took up the quarrel and represented to Philip IV the hardship inflicted on the inquisitors, too old and feeble for the saddle. The compassionate king endorsed on the consulta the customary formula of approval, "I have so ordered." The Suprema then applied to the Council of Castile for a corresponding order, and several communications passed without result. Another consulta was presented to the king, who endorsed it, "I have so ordered" again, but the Council of Castile was still evasive. Then the Logroño authorities offered to the Bishop of Calahorra permission to use coaches, and intimated to the inquisitors that, if they would apply for a license, it would be given. The Suprema forbade them thus to recognize the local magistracy, as they had royal authority, whereupon they resumed the use of their coaches. The alguacil of the corregidor arrested one of their coachmen, and they excommunicated the corregidor. The king, December 9, 1633, ordered him to be absolved, to which, on December 30th, the Suprema replied that he would be absolved if he made application. The Council of Castile presented to the king a consulta, arguing that ecclesiastics and inquisitors alike owed obedience to the laws, and that the corregidor had acted with great moderation. February 5, 1634, the king enquired what had been done with the corregidor, but it was not until December 16th that the Suprema condescended to reply, complaining bitterly of the slight put upon the Inquisition, when the whole safety of the monarchy depended upon its labors. Finally, on February 15, 1635, the Council of Castile sent to the Suprema a license for the use of coaches in Logroño, at the same time intimating that its tax of media añata had not been paid. In the course of the quarrel, the council presented a very forcible consulta to the king, which exhibits the light in which the Inquisition was regarded by the highest authorities of the state. It represented that everywhere the inquisitors and their officials, under color of privileges that they did not possess, were causing grave disorders. They were vexing and molesting the corregidors and other ministers of the king, oppressing them with violent methods, and frightening them with threats of punishment in order to deter them from defending the royal jurisdiction. Thus crimes remained unpunished, justice became a mockery, and the king's vassals were afflicted with what they were made to suffer in their honor, their lives, their fortunes, and their consciences. Trivial quarrels such as this, developed until they distracted the attention of the king and his advisers, were constantly breaking out and bear testimony to the antagonistic spirit which was all-pervading. A long-standing cause of dissension in Logroño may be taken as a type of what was occurring in many other places. Local officials there, as elsewhere, had a perquisite in the public carniceria, or shambles, of dividing among themselves the vientres or menudos, the chitlins of the beasts slaughtered. It was not unnatural that the inquisitors and their subordinates should seek to share in this, but the claim was grudgingly admitted, as it diminished the portions of the town officers, and it led to bickerings. In 1572, Logroño complained to the Suprema that, while it was willing to give each inquisitor the menudo of a sheep every week, the inferior officials down to the messengers claimed the same, and when there was not enough to go round, they caused the slaughter of additional sheep in order to get their perquisite. As the population was poor, living mostly on cow beef, and meat would not keep in hot weather, this caused much waste. Wherefore the town begged that during the 4 hot months the inferior officials should be content with what the town officers received, and during the other 8 months it would endeavor to give them more. To this the Suprema graciously assented, but in 1577 there was another outbreak, to quiet which the Suprema ordered the enforcement of the agreement. In 1584 trouble arose again, and still more in 1593, and in 1601 it reached a point at which the tribunal summoned all the staff of the carniceria and scolded them roundly, giving rise to great excitement. Then, in 1620, there was a worse outbreak than ever, owing to the refusal of the regidor to give one of the inquisitors 2 pairs of sheep stones asked for on the plea that he had guests to breakfast. The angry inquisitor, thus deprived of his breakfast relish, induced the tribunal to summon the regidor before it and severely reprimand him, thus not only inflicting a grave stigma on him, but insulting the town, of which it complained loudly to the Suprema. It is easy to understand how trifles of the kind kept up a perpetual irritation, of which only the exacerbations appear in the records. The privileges of the markets, in fact, were a source of endless troubles. It was recognized that both secular and ecclesiastical officials were entitled to the first choice and to be served first. Those of the Inquisition claimed the same privilege, not only in cities where there was a tribunal, but also where the scattered commissioners and notaries resided. That this was frequently resisted is shown by the formula of mandate to be used in such cases, addressed to the corregidor or alcaldes, setting forth that the rights in this respect of the aggrieved party had not been respected, and that in future he should have the first and best, after the secular and ecclesiastical officials had been served, of all provisions that he required at current prices, and this under penalty of 20,000 maravedis, besides punishment to the full rigor of the law. It does not appear that there really was any legislation entitling the Inquisition to this privilege, but in the frequent troubles arising from its assertion, the inquisitors acted with their customary truculence. A writer in 1609, who deprecates these quarrels, suggests as a cure that the king issue a decree that the representatives of the Inquisition shall have preference in purchasing, and, at the same time, he tells of a case in Toledo where a regidor, who told the steward of the tribunal to take as many eggs as he wanted, but no more, was arrested and prosecuted, and of another in Cordova, where an hidalgo, who had bought a shad and refused to give it up to an acquaintance of a servant of an inquisitor, was punished with 200 lashes and sent to the galleys. In 1608 the Suprema issued an injunction that purveyors of inquisitors should take nothing by force, the significance of which lies rather in the indication of existing abuses than in its promise of their removal. The claim of preference was pushed so far that in Seville in 1705 there arose a serious trouble because the servant of an inquisitor detained boatloads of fish coming to market in order to make his selection, and it required a royal cedula of March 26, 1705, forbidding inquisitors to detain fish or other provisions on the way, or to designate by banderillas the pieces selected for themselves. When we consider the character of the slaves and servants thus clothed with authority to insult and browbeat whomsoever they chose, in the exercise of such functions, we can conceive the wrath and indignation stored up against their masters in the thousands of cases where fear prevented an explosion. It is true that the Suprema issued instructions that all purveyors should behave themselves modestly and give no ground of offense, and that no one should be summoned or imprisoned for matters arising out of provisions, but as usual these orders were disregarded. Insolence would naturally elicit a hasty rejoinder, which, as reported by the servant to his master, would imply disrespect towards the Holy Office, and severe punishment would be justified on that account. End of Book 2, Chapter 5, Part 1. Recording by Margaret Espaillat, Orlando, Florida. Book 2, Chapter 5, Part 2 of History of the Inquisition of Spain, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. History of the Inquisition of Spain, Volume 1 by Henry Charles Lee, Book 2, Chapter 5, Popular Hostility, Part 2. Perhaps less irritating but more serious in its effects was the use made of the fuero by those engaged in trade. Inquisitor General Deza in 1504 issued a stringent prohibition against any salaried official having an interest, direct or indirect, in any business. Daily experience, he said, showed how much opprobrium and disturbance it brought upon the Inquisition. Wherefore he decreed that it should, ipso facto, deprive the offender of his position and subject him to a fine of 20,000 maravedis. He should cease to be an official as soon as contravention occurred, and the receiver, under pain of 50 ducats, should cut off his salary. All officials cognizant of such a case should notify the Inquisitor General within 15 days, under pain of major excommunication, and this order was to be read in all tribunals in presence of the assembled officials. The severity of this regulation indicates the recognized magnitude of the evil, and its retention in the compilation of instructions shows that it was considered as remaining in force. Like all other salutary rules, however, it was slackly enforced from the first, and the Catalans took care to have the prohibition embodied in the bull Pastoralis Officii. It gradually became obsolete. A royal decree of August 9, 1725, in exempting from taxation the salaries officials of the Tribunal of Saragossa, adds that, if they possess property or are in trade, those assets are taxable, showing that their ability to trade was recognized. How aggravating was the advantage which they thus enjoyed can be gathered from a Valencia case of about 1750. Joseph Segarra, the contador of the tribunal, entered into partnership with Joseph Miralles, a carpenter, to bring timber from the Sierra de Cuenca. In the settlement, Segarra claimed from Miralles a balance of 1,779 libras. They entered into a formal agreement to accept the arbitration of Dr. Boyle, but Segarra rejected the award, and Miralles sought to enforce it in the royal court. Then the tribunal intervened, asserting the award to be invalid because Segarra could not divest the Inquisition of its jurisdiction, and it refused the request of the regent for a conference and a competencia. Evidently it was dangerous to have dealings with officials. They always had a winning card up the sleeve to be played when needed. As regards the great army of familiars, it was of course impossible to prevent them from trading. In fact, traders eagerly sought the position in view of the advantages it offered of having the Inquisition at their backs, whether to escape payment of debts, or to collect claims, or to evade customs dues, or in many other ways not recognized by the Concordias, but allowed by the tribunals. The Suprema occasionally warned the inquisitors not to appoint men of low class, such as butchers, pastry cooks, shoemakers, and the like, or traders whose object was protection in their business. But no attention was paid to this. A large portion of the familiars was of this class, and the space occupied in the formularies by forms of levy and execution and sale and other similar matters shows how much business was brought to the tribunals by the collection of their claims. The opportunities thus afforded for fraudulent dealings, for evading obligations, and for enforcing unjust demands were assuredly not neglected, and may be reckoned among sources of the animosity felt for everyone connected with the Holy Office. In the remarkable paper presented in 1623 to the Suprema by one of its members, many of the abuses of the Inquisition are attributed to the indifferent character and poverty of the officials. It would be well, the writer says, to appoint none but clerics, holding preferment to support themselves and unencumbered with wife and children. They would not, when dying, leave penniless families, which obliges the Inquisitor General to give to the children their fathers' offices, thus bringing into the tribunals men who cannot even read. An increase of salaries also would relieve them from the necessity of taking bribes under cover of fees, and thus would put a stop to the popular murmurs against them. The inquisitors, moreover, should have power of removal, subject to confirmation by the Suprema, for now their hands are tied, their subordinates are unruly and uncontrollable. The greatest injury to the reputation of the Holy Office arises from its bad officials, who recognize no responsibility. No one should be appointed to office or as a familiar who is a tailor, carpenter, mason, or other mechanic. It is these people who cause quarrels with the secular authorities, for they have little to lose and claim to be inviolable. In short, if we may believe the writer, the whole body of the tribunals, except the inquisitors, was rotten. None of the officials, from the fiscals down, were to be trusted, for all were eagerly in pursuit of dishonest gains, robbing the Inquisition itself and all who came in contact with it, and to this he attributed its loss of public respect and confidence. Matters did not improve, for the Suprema always defended the tribunals from all complaints, and its tenderness towards delinquents assured them of virtual impunity. At length, as we have seen, in 1703, Philip V made an attempt at reform. It was probably owing to this pressure that in 1705 the Suprema issued a Carta Acordada prohibiting a number of special abuses, and pointing out that, in regard to the proprieties of life, neither inquisitors nor officials obeyed the instructions, consorting with improper persons, and intervening in matters wholly foreign to their duties, thus rendering odious the jurisdiction of the Holy Office. From various incidents alluded to above, it is evident that this produced little amendment, but, when the vacillation of Philip V was succeeded by the resolute purpose of Carlos III and his able ministers, the power of the Inquisition to oppress was greatly curbed. It was not alone the commonalty that had reason to complain of the extended jurisdiction claimed by the Inquisition. The feudal nobles, whose rights were already curtailed by the growth of the royal power, were restive under the interjection of this new and superior jurisdiction, which recognized no limitations or boundaries, and interfered with their supremacy within their domains. Thus, in 1553, the Duke of Najera complained that, in his town of Navarrete, the commissioner of the Inquisition had insulted his alcalde mayor, and then, with some familiars, had forcibly taken wheat from his alguacil. Inquisitor General Valdez wrote to the tribunal of Calahorra to investigate the matter and to punish the officials if found in fault. The alcalde and alguacil were not to be prosecuted save for matters pertaining to the Inquisition, and this not only in view of its proper administration, but because he desired to gratify the duke. A still more serious cause of complaint, to which the nobles were fully alive, was the release of their vassals from jurisdiction by appointment to office. In 1549 the Countess of Nieva appealed to Valdez, setting forth that Arnedo was a place belonging to the count. It was within 3 leagues of Calahorra, and there had never been a familiar there until recently Inquisitor Valcleolivas had appointed some peasants in order to enfranchise them from the jurisdiction of their lord. It was not just that, while the count was absent from the kingdom on the king's service, his peasants should be thus honored in order that they might create disturbance in the villages and interfere with the feudal jurisdiction. It may well be doubted whether her request for the revocation of the commissions was granted, but that her prevision of trouble was justified is seen in a case before the Tribunal of Barcelona in 1577, in which Don Pedro de Queral, Lord of Santa Colonia, a powerful noble of Tarragona, endeavored to secure the punishment of 2 of his vassals, Juan Requesens, a miller, and his cousin Vicente. They were both familiars and seem to have been leaders of a discontented opposition which rendered Don Pedro's life miserable. The trees in his plantations were cut down, his arms over the door of his baile in Santa Coloma were removed and defaced, libelous coplas against him were scattered around the streets, but the cousins, being familiars, were safe from his wrath. Don Pedro died, but the trouble continued between his widow, the Countess of Queral, and a new generation of Requesens, who succeeded to their father's office of familiars. Finally, in 1608, she succeeded in convicting Juan Requesens of malicious mischief, but her only satisfaction was that he was reprimanded, warned, and sentenced to pay the costs, amounting to 115.5 reales. Such a case shows how feudalism was undermined, and we can conceive how nobles must have writhed under the novel experience of rebellious vassals clothed with inviolability. It is easy, therefore, to understand the detestation felt for the Inquisition by all classes, laymen and ecclesiastics, noble and simple. It was fully aware of this and constantly alleged it to the king when defending the tribunals in their quarrels, and when urging enlarged privileges as a protection against the hatred which it had excited. In its appeals against the curtailment of its jurisdiction in Aragon, it did not hesitate to admit that it had been hated there from the beginning, and that its officials were so abhorred that they would not be safe if exposed to secular justice, and, even as late as 1727, it repeated the assertion of the persistent hostility of the Aragonese. In Logroño, the inquisitors reported to the Suprema in 1584 that it was a common saying among the people that their life consisted in discord with the tribunal, and that it was death to them when there was peace. It was the same in Castile. The Cortes, in 1566, when encouraging Philip II to constrain the Flemings to admit the Inquisition, gave as a reason that his success there was necessary to the peaceful maintenance of the institution in Spain, thus intimating that, if the Flemings rejected it, the Castilians would seek to follow their example. In the same year the familiars alleged that the detestation in which they were held led them to be singled out for a special oppression in the billeting of troops, and, in 1647, the Suprema declared that nothing seemed sufficient to repress the hatred with which they were regarded, in support of which it instanced an unjust apportionment in Cuenca of an assessment of a forced loan. This hostility continued to the last, even though the decadence of the Inquisition in the 18th century diminished so greatly its powers of oppression. A defender of the institution in 1803 commences by deprecating the hatred which had pursued it from the beginning. Even in the present age, he says, of greater enlightenment, there is crass ignorance of its essential principles and a mortal opposition to its existence. Thus, notwithstanding the Spanish abhorrence of Jews and heretics, the dread which the Inquisition inspired was largely mingled with detestation, arising from its abuse of its privileges in matters wholly apart from its functions as the guardian of the faith. End of Book 2, Chapter 5, Part 2. Recording by Margaret S. Bayat, Orlando, Florida.
Appendix 1, Part 1 of History of the Inquisition of Spain, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. History of the Inquisition of Spain, Volume 1, by Charles Henry Lee. Appendix 1, List of Tribunals, Part 1. The permanent tribunals of the Spanish Inquisition were Toledo, Sevilla, Valladolid, Corta, or Madrid, Granada, Cordova, Murcia, Llerena, Cuenca, Santiago, or Galicia, Logroño and Canaries, under the crown of Castilla, and Saragossa, Valencia, Barcelona, and Majorca, under the crown of Aragon. In addition were Sicily, Sardinia, Mexico, Lima, and Cartagena de las Indias, which lie beyond the scope of the present work. This distribution of the forces of the Inquisition was not reached until experience had shown the most effective centres of action. Numerous more or less temporary tribunals were erected and many changes occurred in the apportionment of territory. The following list makes no pretensions to absolute completeness, but contains the result of such allusions as I have met in the documents. Alcaraz. For some years there was a fixed tribunal at Alcaraz. In 1495 Alonso Hernandez, presented for a canonry, is qualified as Inquisitor of Alcaraz, and in 1499 Alonso de Torres is appointed as Inquisitor there. Army and Navy. The fleet organized for the Catholic League which won at Lepanto seemed to require a tribunal to preserve it from heresy, and Philip II produced from Pius V a brief of July 23, 1571, authorizing the Inquisitor General to appoint an inquisitor for each army of Philip II, whether by land or sea. The first appointment under this seems to have been Rodrigo de Mendoza, Inquisitor of Barcelona, whose commission as Inquisidor de las Galeras is dated March 21, 1575, together with one for his notary, Domingo de Leon, and instructions as to his duties. He was succeeded by Geronimo Manrique, who celebrated an auto de fe in Messina. After him was Dr. Juan Bautista de Cardona, but merely as commissioner, who served for 2 years, when Paramo, writing in 1598, tells us that the fleets were scattered and the office ceased to exist. If so, it was revived, for, in 1622, we are told that Fray Martin de Vivanco, chaplain of the galleys of Sicily, was appointed Inquisidor del Mar, and in 1632, it is stated that when a Principe del Mar was appointed, he took with him an inquisitor and officials, and all prisoners arrested by them were delivered to the nearest tribunal when the galleys made port. In later times the Inquisitor General was Vicario General de los Reales Ejercitos de Mar y Tierra, and as such appointed subdelegates to accompany the army, with the necessary powers. The jurisdicción castrense enjoyed by military men did not exempt them in matters of faith from the Inquisition, but the subdelegados castrenses seems to have possessed no judicial powers, and debate arose, in 1793, and again in 1806, whether they or the episcopal ordinaries should be called in to vote with the inquisitors in the cases of soldiers. Avila. When Torquemada built his convent of San Tomas in Avila, he provided accommodations for an inquisition, and in 1590 the prisoners accused of the murder of the Santo Niño de la Guardia were transferred thither from the tribunal of Segovia for trial. It continued to exist for some years and had connection with Segovia, for, June 9, 1499, Francisco González of Fresneda and Juan de Monasterio were appointed inquisitors of Avila and Segovia, residing sometimes in one city and sometimes in the other. Balaguer. There were autos de fe celebrated in Balaguer, August 15, 1490, and June 10, 1493, but these were held by the inquisitors of Barcelona, as they did in Tarragona, Gerona, Perpignan, and other places in their district. In 1517, however, there would seem to be a tribunal there, for a letter of the Suprema relates to the murder of the assessor of the Inquisition of Balaguer. If so, it was probably withdrawn in consequence, for in 1518 the inquisitors of Barcelona are ordered to publish edicts against those who molest the clergy of Balaguer, for observing the interdict cast upon the town. Barbastro. As early as 1488 there was a tribunal with inquisitors at Barbastro, but in 1521 it was suppressed and incorporated with Saragossa. Barcelona. Established in 1486, it claimed jurisdiction over the Free Republic of Andorra, which was included by Arevalo de Souza in his visitation of 1595. Long after Roussillon and Cardagne had been retroceded to France, the Barcelona inquisitors in 1595 still styled themselves Inquisidores Apolistos, en el Principado de Cataluña y su partido con los condados de Roussillon y Cerdaña y los vals de Arán y Andorra. C. Loreda, Tarragona, Tortosa, Balaguer. Burgos. There was originally a tribunal in Burgos, but, in the redistricting by Ximenes, it was included in Valladolid. In 1605, Philip III transferred the tribunal to Burgos, with orders to the inquisitors to eject any occupants of buildings that they might find suited to their purposes. In 1622 it was still rendering yearly reports of cases to the Suprema, but probably about 1630 it returned to Valladolid. When, in 1706, Madrid was captured by the allies under Galloway and Las Minas, the court fled to Burgos, carrying the Inquisition thither, but its stay was short and it soon returned to the capital. Cadiz. See Xeres. Calahorra. A tribunal was established here as early as 1493, when it celebrated an auto at Logroño. In 1499 it alternated between Calahorra and Durango. In the redistricting by Ximenes in 1509, it was incorporated with Durango, but was soon re-established. Cedulas of 1516, 1517, and 1520 indicate that, at this time, it was tribunal of the enormous district of Valladolid, but in 1522 the Inquisition of Navarre was extended over Calahorra. Then Navarre and Calahorra were separated, but in 1540 there was a redistribution, and Navarre and the Basque provinces were added to Calahorra. In 1560 a part of the territory of Burgos was set off from Valladolid and added to Calahorra, and, in 1570, the seat of the tribunal was definitely moved to Logroño. Calatayud. Calatayud was the seat of an intermittent tribunal at least from the year 1488, for in 1502 Ferdinand speaks of Juan de Agoviva, who for 14 years had served it as barber surgeon whenever it presided in Calatayud, and one of the first presentations to a prebend, in 1488, was Martin Marquez, described as fiscal of the Inquisition of Calatayud. A letter of the Suprema, January 22, 1519, addressed to the Inquisitor of Calatayud, shows that it was still in existence, but it must soon afterwards have been merged into Zaragoza. Canaries. The zeal of Diego de Moros, Bishop of Canaries, did not wait for the extension of the Spanish Inquisition over his diocese, but led him to establish an episcopal one by proclamation of April 28, 1499. It was not until 1504 that Inquisitor General Deza sent Bartolomé López de Trebaldos thither to establish a tribunal at Las Palmas, which seems to have commenced business October 28, 1505. It continued thus to the end. Cartagena. See Murcia. Ciudad Real. A letter of Ferdinand, November 8, 1483, announces the appointment of Licenciados Constanza and de Baltazar as inquisitors for Ciudad Real. May 10, 1485, Ferdinand announces the transfer of Costana to Toledo, to which place the tribunal was removed. Cordova. A tribunal was established in Cordova as early as 1482, at the instance of its bishop, the New Christian Alonso de Burgos. Its district comprised the bishoprics of Cordova and Jaén, the Abadia de Alcalá de la Real, the adelantamiento of Cazorla, with Ecija and Estepa, to which Granada was added after the conquest. See Granada and Jaén. Corte. The Tribunal of Madrid was technically known as Corte. Madrid, originally a town of no special importance, belonged to the province of Toledo, and was naturally under the jurisdiction of its tribunal. As the royal residence under Philip II and eventually the capital of the kingdom, except during the brief transfer to Valladolid, 1600 to 1606, it furnished a large part of the business of Toledo. Toledan inquisitors came there to make investigations and even to try cases, of which we have examples in 1590 and 1592. Something more than this was felt to be needed, and the Suprema adopted the plan of calling inquisitors from other places to commence prosecutions and act under its instructions, of which the Licenciado Flores, Inquisitor of Murcia, in 1593, and Cifuentes de Loarte, Inquisitor of Granada, in 1615, are examples. The presence of the Inquisitor General, who did not hesitate to take action in emergencies, and that of an experienced commissioner, together with the frequent sojourn of one of the Toledo inquisitors, enabled speedy action to be taken when requisite, as occurred in 1621 and again in 1624, and seemed to render superfluous the organization of a special tribunal. Yet the want of it was felt, especially with the influx of Portuguese New Christians, who multiplied in the capital. As the pressure increased, Toledo furnished 2 assistant inquisitors to reside in Madrid, thus establishing a kind of subordinate court, but in 1637 it was reported that the establishment of a tribunal was positively resolved upon, with the added comment that this would sorely vex the Toledans. To their natural opposition it is doubtless to be attributed the postponement of what, to a Spaniard of the period, would seem a necessity to the capital. It cannot have been long after this that one was organized for, in the matter of the confiscation of Juan Cote, commenced in Toledo. We find it, September 10, 1640, sitting in Madrid, with Francisco Salgada and Juan Adam de la Parra as inquisitors. In the same year they suggested that the case of Benito de Valdepeñas, on which they were engaged, should be sent to Toledo as more convenient for the witnesses, which was accordingly done. Toledan influence is doubtless responsible for the action of Arce y Reynoso, soon after his accession in 1643, in suppressing the new tribunal and restoring the business to Toledo. The pressure, however, became too great, and Arce y Reynoso was obliged to reverse his action. The date of the re-establishment may safely be assumed as 1650, for a list of penitents, reconciled by Corte from the beginning, starts with 3 in 1651, and their trials can scarce have been commenced later than 1650. Yet the relations between Toledo and Madrid continued intimate. In 1657, Lorenzo de Sotomayor styles himself as Inquisidor Apostolico de la Inquisición de la Ciudad y Reino de Toledo y Asistente de Corte. To the end of the century, the former always alluded to Corte as a despacho or office and not as a tribunal, and Corte seems to have sent its convicts to Toledo for their sentences to be published in the autos de fe. Its jurisdiction was strictly limited to the city, while the surrounding country remained with Toledo. In some respects its organization was peculiar. About 1750 we are informed that its inquisitors were drawn from other tribunals who continued them on their payrolls, their places being taken by appointees who served without salary until a vacancy occurred. Selection to serve in Corte was regarded as a promotion, leading to a place in the Suprema or to a bishopric, although the incumbent drew only the salary from his former tribunal, with a Christmas propina of 100 ducats. It had no receiver, the Suprema paid its expenses and presumably collected its fines and confiscations. Cuenca. Murcia and Cuenca were originally under one tribunal. Some trouble apparently arose, possibly connected with the episcopal ordinaries, for Ximenes ordered, January 22, 1512, that cases originating in Murcia should be taken to Cuenca to be voted on and vice versa. Llorente says that in 1513 they were separated and Cuenca formed an independent tribunal, but documents as late as 1519 show them still connected, until, in 1520, we find Cuenca celebrating an auto. A letter of March 7, 1522, states that the Pope has given to Cuenca the see of Sigüenza, without taking it from Toledo, because Toledo has never visited it, although ordered to do so, and is not to do so in future. Then, May 31, 1533, the Suprema says that Toledo can exercise jurisdiction there without giving Cuenca cause of complaint, and in 1560, Sigüenza was restored to Toledo, yet in 1584 we find Cuenca exercising jurisdiction as far north as Soria. There would seem to have been some connection maintained between Murcia and Cuenca, for, in 1746, the former, in enumerating its personnel, specifies 9 calificadores in Murcia and 4 in Cuenca. Daroca. There would appear to have been for a time a tribunal in Daroca, for, in the accounts of Juan Royes, receiver of Aragon for 1498, there is an item of expenditure on the prison of the Inquisition there, which was duly passed. Durango. See Calahorra. As defined by Ximenes in 1509, Durango had jurisdiction over Biscay, Guipuzcoa, Alava, and Calahorra, with some neighboring districts. Estella. See Navarre. Galicia, also known as Santiago. The earliest allusion to this tribunal occurs in a commission issued at Coruña, May 20, 1520, to Dr. Gonzalo Maldonado as Inquisitor of Santiago. It was probably some time before the tribunal was in working order, but in 1527 it had caused sufficient alarm for the Suprema to write to João III of Portugal asking for the arrest and surrender of those who had fled from it, and in the same year a warrant for 300 ducats was drawn to be distributed among the inquisitors and officials of the Inquisition of Galicia. This was followed by a similar payment in 1528, showing that the tribunal was not self-sustaining. Apparently the harvest was scanty and the tribunal was allowed to lapse, until the scare about Protestantism called attention to the ports of the northwest as affording ingress to heretics and their books, for we hear nothing more about it until 1562, when Philip II, in letters of June 2nd and 26th, informs the governor and officials of Galicia that Valdes had dispatched Dr. Quijano there as inquisitor. They are no longer to prosecute cases of heresy as they have been doing, but are to lend him all aid and favour, and are to allow him to dispose as he pleases of the seats in his public functions, without disputes as to precedence. In 1566 we hear of Bartolomé de Leon as receiver there, which would indicate that it was at work and was making collections. Still, it had a struggle for existence, for it was discontinued early in 1568, but it was re-established within a few years, if Llorente is correct in saying that its first auto de fe was celebrated in 1573. A letter of Dr. Alva, its inquisitor, October 31, 1577, speaks of having, in the previous year, sentenced Guillaume de Meunier, he being the only inquisitor, with the advice of a single consultor, showing that the tribunal was sparingly equipped. In later years it became one of the active tribunals of the kingdom. Its district comprised Coruña, Pontevedra, Orense, and Lugo. Granada. Granada, after its capture, was included in the inquisitorial district of Cordova until, in 1526, the tribunal of Jaen was transferred thither. Guadalupe. A temporary tribunal was organized here in 1488, which during its brief existence was exceedingly efficient. See page 171. Huesca. See Lerida. Jaca. A tribunal apparently existed here, which was annexed to Saragossa in 1521. Jaen. A tribunal must have been established here about 1483, for two of its inquisitors took part in the Assembly of Seville, which framed the instructions of 1484. It seems to have been discontinued, for September 2, 1501, Ferdinand ordered a certain Dona Beatriz of Jaen to abandon her house to the inquisitors sent thither, and seek other quarters until they should finish the business that took them there. This indicates that only a temporary tribunal was intended, but the situation was conveniently central, and it was one of those retained by Ximenes in his reorganizations of 1509, when he assigned it to the districts of Jaen and Guadix, with Alcaraz, Cazorla, and Beis. It was still in existence in 1525, as shown by a royal letter of that date, but in 1526 it was suppressed and united with Cordova, the tribunal being transferred to Granada. In 1547 the official title of the tribunal was Cordova y Jaen. Rodrigo tells us that it was re-established independently in 1545, but this is evidently an error, and the name does not reappear in subsequent lists of tribunals. End of Appendix 1, Part 1. Appendix 1, Part 2 of the History of the Inquisition of Spain, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. History of the Inquisition of Spain, Volume 1, by Henry Charles Lee. Appendix 1. List of Tribunals, Part 2. Leon. In 1501 we hear of inquisitors of the province of Leon, whose district cannot have been confined to that province, for Ferdinand, writing September 2nd to cousin Duke, tells him that they have occasion to go to his city of Coria, Extremadura, and asks that they may occupy his house while there. In 1514, also, there is allusion to the receiver and alguazil of the Inquisition of Leon. Apparently the term is a synonym of the Tribunal of Valladolid. Lerida. The provinces of Huesca in Aragon and Lerida and Urgel in Catalonia were united as an inquisitorial district at least as early as 1490, when we hear of the inquisitors of Huesca and Lerida taking testimony. In 1498 a letter of Ferdinand, October 8, announces the transfer of Urgel to Barcelona. Allusions to the tribunal continue to occur in the correspondence of Ferdinand, who in 1502 called away the inquisitor, as there was so little to do. Saragossa would not attend to heresy, and only the financial officials need be left. It was not discontinued, however. In 1514 there was an attempt to murder the inquisitor, Canon Antist, but in 1519 he is still addressed as Inquisitor of Lerida. In this same year, however, Charles V, in a letter of January 22, speaks of the tribunals of Huesca, Tarazona, and Lerida having been united with that of Saragossa, and when the people of Huesca complained, in the Cortes of Saragossa, of their citizens being carried away for trial, he ordered, under pain of 1,000 florins, that no one should interfere with the jurisdiction of the Saragossa tribunal. October 9 an inspector reported that there was no need of a receiver or other officials there, whereupon they were all dismissed. In 1532, however, the inquisitors of Saragossa undertook to appoint a receiver for Lerida, but were told by the Suprema to cancel it as this was a function of the crown. Logroño. In 1570, as we have seen, the tribunal of Calahorra was shifted to Logroño, which in 1690 defines its territory as the whole kingdom of Navarre, the bishopric of Calahorra and La Calzada, Biscay, Guipuzcoa, Burgos along the mountains of Oca, and the sea-coast as far as San Vicente de la Barquera, thus comprising the modern provinces of Navarre, Guipuzcoa, Biscay, Santander, Alava, Logroño, and a large part of Burgos. Llerena. Originally, Extremadura and Leon were combined. In 1500, Enrique Paez is receiver for the sees of Plasencia, Coria, and Badajoz, and the province of Leon. In 1509, Ximenes assigned to Lereda as its district, Plasencia, Coria, Badajoz, and the lands of the military orders, but as late as 1516 it is spoken of as the Inquisition of Leon, Plasencia, Coria, and Badajoz. Its original seat was Llerena, but in 1516 it was transferred to Plasencia, and the receiver was ordered to sell the houses purchased at Llerena for the prison, because others will be wanted for the purpose at Plasencia. It was migratory, however, and in 1520 the people of Ciudad Rodrigo, Coria, and Herida were notified that it was about to leave Plasencia, and wherever it went accommodations must be provided for lodgment, audience chamber, and prisons. Finally, it settled permanently at Llerena, and towards the close of the 16th century Zapata speaks of it as the first tribunal of the kingdom, with the widest jurisdiction. Madrid. See Corte. Medina del Campo. The great importance of Medina del Campo as a centre of trade rendered inevitable its selection as the seat of a tribunal at an early period. In 1486 it was fully furnished with 3 inquisitors and an assessor, the abbot of Medina serving as ordinary. In 1516 we find it incorporated with Valladolid. When the court moved to Valladolid, the buildings of the Inquisition were wanted for its accommodation, and the tribunal, in June 1601, was unceremoniously sent to Medina, where Dr. Martin de Bustos was turned out of his house to lodge it. Its stay was short, for in 1605, as we have seen, it was transferred to Burgos, and there is no later trace of a tribunal at Medina. Murcia, also known as Cartagena. See also Cuenca. Murcia was a seat of one of the early tribunals, comprising the sees of Murcia and Cartagena. Cuenca, which was attached to it in the redistribution by Ximenes in 1509, was separated about 1520. Oran, some time after its conquest by Ximenes, was placed under the jurisdiction of Murcia. The see of Orihuela, although belonging to Valencia, on its suppression about 1510, was united to that of Cartagena, and thus fell under the tribunal of Murcia, where it remained after the restoration to episcopal honours in 1564. The tribunal of Orihuela naturally followed the same course on its suppression. Navarre. After the conquest of Navarre in 1512, a tribunal was established in Pampeluna, where it did not long remain. Then for a short period it was transferred to Estella. In 1515 we find it in Tudela, where Ferdinand orders the Archdeacon of Almazan to visit it as it is in much need of reform, and soon afterwards he asks for a delegation of episcopal power, as Tudela was only a deanery. It was quartered in the convent of San Francisco, to relieve which, in 1518, the Suprema ordered appropriate buildings to be obtained. In 1521 and 1522 there was talk of removing it to Pampeluna. Then it was extended over Calahorra. Soon afterwards they were separated, but finally in 1540 they were united and so remained. Soon after the transfer to Logroño we find the tribunal describing itself as "en todo el Reino de Navarra, Obispado de Calahorra y la Calzada y su distrito." Navy. See Army. Oran. Paramo tells us that when Ximenes conquered Oran he commissioned Fray Yedra as inquisitor there. Lorente places this in 1516 and calls the inquisitor Martin de Baedecar, Ximenes' provisor. At that time, however, there could have been no tribunal there, for July 9, 1516, the governor Lope Hurtado de Mendoza was ordered to discover and punish those who were impeding the sale of property for the Inquisition, work which would have been entrusted to the tribunal had there been one. By this time it had probably been suppressed and placed under Murcia. Orihuela. According to Lorente, Ferdinand, August 7, 1507, united the tribunal of the bishopric of Orihuela to Valencia, which would infer its previous existence. It was reorganized in 1515, when Bishop Mercader appointed Pedro de los Rios as inquisitor, and he was sent there with a staff of officials, and the magistrates were ordered to provide quarters for el tiempo que fuere menester. This indicates that the tribunal was not expected to be permanent, and it was probably not long afterwards that it was united with Murcia. Osuna. In 1488, among the presentations to Brebens is one of Pedro Sanchez, qualified as Inquisitor of Osuna. Such tribunal can only have been short-lived, and must speedily have been incorporated with that of Seville. Pampeluna. See Navarre. Perpignan. August 9, 1495, an auto de fe was celebrated in Perpignan, but it was held by the inquisitors of Barcelona. In 1518 there was only a commissioner there, but in 1524 there was a tribunal, with Juan Navardu as inquisitor and Antonio Salateda as secretary. It was not permanent, however. In 1566, when Soto Salazar was sent on his visitation to Barcelona, he was instructed to ascertain and report promptly details for the benefit of the inquisitor about to be sent to Perpignan to reside for the future, and what officials should be provided for him. It is doubtful whether this intention was carried out; in any event it was but transitory. Plasencia. See Llerena. Santiago. See Galicia. Saragossa. Established in 1484, the tribunal gradually absorbed all the minor tribunals, but parted with Teruel to Valencia. See Babastro, Calatayud, Daroca, Jaca, Lereda, Tarazona, Teruel. Segovia. Segovia claimed the honor of being among the earliest cities, after Seville, to possess a tribunal, but there was no representative from there among the inquisitors assembled to frame the Instructions of 1484, owing doubtless to the resistance of the bishop Juan Arias Davila. One must have been established soon afterwards, for, in 1490, the prisoners accused of the murder of the Santo Niño de la Guardia were on trial there, when Torquemada transferred them to Avila. See Avila. In the redistribution by Ximenes in 1509, Segovia was incorporated with Valladolid, but in 1544 and again in 1599 the inquisitors of Toledo include it in their enumerations of their jurisdictions. Sigunza. A tribunal was early established in Sigunza, which must have been busy if we may believe the statement that an auto de fe in 1494 it relaxed 149 victims to the secular arm. In 1506 Deza dismissed the officials for the reason that it was about to be united with Toledo, a merger ratified by Ximenes in 1509. Toledo neglected it and it was transferred to Cuenca. In the 18th century there would appear to be some kind of subordinate tribunal there, for about 1750 Saragossa, in a report of its personnel, states that one of its 5 inquisitors is assisting at Sigunza. Tarazona. A tribunal established here in the early period was merged into that of Saragossa in 1519. Tarragona. When in 1643 the inquisitors of Barcelona were ejected, they were, after some delay, sent to open their tribunal at Tarragona, where they remained until the suppression of the Catalan rebellion in 1652. Teruel. In 1485 a tribunal was established in Teruel after some resistance. At what time it was transferred to Valencia does not appear, but a cedula of October 2, 1502, is addressed to the inquisitors of Valencia residing in Teruel and Albarracin, showing that it was then subordinate to Valencia. In 1518 it was discontinued and the district was subject to the direct jurisdiction of the Valencian tribunal, but Cardinal Adrian, by a provision of November 21 of the same year, transferred it to Saragossa, and then, March 3, 1519, restored it to Valencia. This was felt by Aragon as a grievance, and at the Cortes of Monzon, in 1533, it asked that Teruel and Albarracin should be restored to the Saragossa tribunal, but the request was peremptorily refused, and they remained subject to Valencia. Toledo. In 1485 the tribunal of Ciudad Real was transferred to Toledo. At first the limits of its district seemed not to be clearly defined, for in 1489 the inquisitors were told to go to Guadalajara and Ferdinand ordered the local authorities to show them favour and allow them to make arrests. See Corte, Cuenca, Segovia, Sigunza, Valladolid for sundry changes in the district. In 1565 the official designation is the city and archbishopric of Toledo, the city and bishopric of Sigunza, and the bishoprics of Avila and Segovia, which apparently remained permanent, except the detachment of Madrid. Tortosa. For some reason the bishopric of Tortosa, although part of Catalonia, was subject to the tribunal of Valencia. When in 1697 Vendome captured Barcelona, the tribunal emigrated to Tortosa and established itself in the Colegio Imperial. Although peace was declared soon afterwards, it remained in Tortosa at least until 1700 and presumably stayed until the conclusion of the War of Secession, when it was reinstated in Barcelona in 1715. Tudela. See Navarre. Valencia. The old Inquisition of Valencia was reorganized in 1484, and continued to the end. As seen above, it parted with Orihuela to Murcia, obtained Teruel and Albarracin from Saragossa, and Tortosa from Barcelona. Valladolid. A tribunal was assigned to Valladolid in 1485, but did not get into working order until 1488. After this it was suspended, to be revived in 1499, as appears from a letter of Isabella, December 24, 1498. The northern provinces of Spain were comparatively free from heresy, and Ximenes, in his reorganization of 1509, assigned to Valladolid the enormous district comprising the sees of Burgos, Osma, Valencia, Segovia, Avila, Salamanca, Zamora, Leon, Oviedo, and Astorga, and the abbeys of Valladolid, Medina del Campo, and Sahagun. In 1516 the enumeration is the same except the omission of Zamora and the addition of Ciudad Rodrigo and Calahorra. Roughly speaking, it may be assumed to comprise the whole of the provinces of Old Castile, Leon, and Asturias. Valdes, August 8, 1560, repeated April 12, 1562, made over the whole of this to Toledo, but the grant can only have been temporary, for in 1565 the Toledan inquisitors described themselves as of the city and archbishoprics of Toledo, the city and bishopric of Sigunza, with the bishoprics of Avila and Segovia, and in 1579 we find the inquisitors of Valladolid styling themselves inquisitors of the kingdoms of Castile and Leon and the Principality of Asturias. This enormous district it continued to retain, subject to the easternmost portion detached to Calahorra or Logroño, and to its translation in 1601 to Medina del Campo, and thence to Burgos, from which it was returned to Valladolid, probably about 1630. Xeres. In 1495 Rodrigo Locaro is described as inquisitor of Xeros. In 1499 the sovereigns appointed Alonso de Guevara inquisitor of Cadiz and Xeres. The tribunal continued there for some time. In 1515 Ferdinand alludes to Luis de Riba Martin, our late receiver in the Inquisition of Xeres, who in dying had left to the treasury a legacy of 30,000 emires for the relief of his conscience. I have met no later reference to it, and it probably was soon afterwards merged into the Tribunal of Seville. End of Appendix 1, Part 2. Appendix 2 of the History of the Spanish Inquisition of Spain, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. History of the Inquisition of Spain, Volume 1, by Henry Charles Lee. Appendix 2. List of Inquisitors General. 1483. Tomás de Torquemada, appointed in 1483, died September 16, 1498. 1491. Miguel de Morillo is also Inquisitor General in 1491. Additional Inquisitors General, appointed in 1494. 1494. Martin Ponce de Leon, Archbishop of Messina, died in 1500. Inigo Manrique, Bishop of Cordova, died March 4, 1496. Francisco Sanchez de la Fuente, Bishop of Avila, died September 1498. Alonso Suarez de Fuentesas, Bishop of Jaen, resigned in 1504, died November 5, 1520. 1498. Diego Deza, Archbishop of Sevilla, commissioned November 24, 1498, for Castile, Leon, and Granada, and September 1, 1499, for all Spain. Resigned in 1507. Died July 9, 1523. Separation of Inquisitions of Castile and Aragon. Castile, 1507. Francisco Jimenez de Cisneros, Cardinal and Archbishop of Toledo, commissioned June 5, 1507. Died November 8, 1517. Aragon, 1507. Juan Enguera, Bishop of Vich, of Lereda in 1511. Commissioned June 6, 1507. Died February 14, 1513. 1513. Luis Mercader, Bishop of Tortosa, commissioned July 15, 1513. Died June 1, 1516. Fray Juan Pedro de Paul, Dominican Provincial of Aragon, also commissioned by Leo X. Died in 1516. 1516. Adrian of Utrecht, Cardinal and Bishop of Tortosa, commissioned November 14, 1516. Reunion of Inquisitions of Castile and Aragon. 1518. Cardinal Adrian of Utrecht, commissioned March 14, 1518. Elected to papacy January 9, 1522. Continued to act until his departure for Rome from Tarragona, August 4, 1522. 1523. Alfonso Manrique, Cardinal and Archbishop of Sevilla, commissioned September 10, 1523. Died September 28, 1538. 1539. Juan Pardo de Tavera, Cardinal and Archbishop of Toledo, appointed June 10, 1539. Commissioned November 7, 1539. Took possession December 7, 1539. Died August 1, 1545. 1546. Francisco Garcia de Loaisa, Archbishop of Sevilla, commissioned February 18, 1546. Took possession March 29, 1546. Died April 22, 1546. 1547. Fernando Valdez, Archbishop of Sevilla, commissioned January 20, 1547. Took possession February 19, 1547. Resigned in 1566. Died December 9, 1568. 1566. Diego Espinosa, Cardinal and Bishop of Sigunza, commissioned September 8, 1566. Took possession December 4, 1566. Died September 15, 1572. 1572. Pedro Ponce de Leon y Cordova, Bishop of Plasencia, commissioned December 7, 1572. Did not take possession. His brief arrived 4 hours after his death, January 17, 1573. 1573. Gaspar de Quiroga, Cardinal and Archbishop of Toledo. Commissioned April 20, 1573. Took possession May 28, 1573. Died November 12, 1594. 1595. Geronimo Manrique de Lara, Bishop of Avila. Commissioned August 1, 1595. Died November 1, 1595. 1596. Pedro de Portocarrero, Bishop of Cuenca. Commissioned January 1, 1596. Resigned in 1599. Died September 20, 1600. 1599. Fernando Niño de Guevara, Cardinal and Archbishop of Seville. Commissioned August 11, 1599. Took possession December 23, 1599. Resigned in 1602. Died January 1, 1609. 1602. Juan de Zuniga, Bishop of Cartagena. Commissioned July 29, 1602. Died December 20, 1602. 1603. Juan Bautista Acevedo, Royal Confessor and Patriarch of the Indies. Commissioned January 20, 1603. Died July 8, 1608. 1608. Bernardo de Sandoval y Roxas, Cardinal and Archbishop of Toledo. Commissioned September 12, 1608. Died December 7, 1618. 1619. Luis de Aliaga, Royal Confessor. Commissioned January 4, 1619. Resigned in 1621. Died December 3, 1626. 1622. Andres Pacheco, Bishop of Cuenca. Commissioned February 12, 1622. Died April 7, 1626. 1627. Antonio de Zapata, Cardinal and Archbishop of Burgos, 1600 to 1605. Commissioned January 30, 1627. Resigned in 1632. Died April 23, 1635. 1632. Antonio de Sotomayor, Royal Confessor and Archbishop of Damascus. Commissioned July 17, 1632. Resigned June 21, 1643. Died in 1648. 1643. Diego de Arce y Reynoso, Bishop of Plasencia. Commissioned September 18, 1643. Took possession November 14, 1643. Died June 20, 1665. 1665. Pascal de Aragon, Archbishop of Toledo. A document of October 26, 1665, is drafted in his name. Resigned soon afterwards. 1666. Juan Everardo Nethardo, Royal Confessor and Cardinal. Commissioned October 15, 1666. Banished February 25, 1669, as ambassador to Rome. Died in 1681. 1669. Diego Sarmiento de Valadares, Bishop of Plasencia. Commissioned September 15, 1669. Died January 29, 1695. 1695. Juan Tomas de Rocoberti, Archbishop of Valencia. Commissioned August 2, 1695. Died June 13, 1699. 1699. Alfonso Fernandez de Cordova y Aguilar. Died September 19, 1699, before the arrival of his brief. 1699. Balthazar de Mendoza y Sandoval, Bishop of Segovia. Commissioned October 31, 1699. Resigned in 1705. Died November 4, 1727. 1705. Vidal Marin, Bishop of Ceuta. Commissioned March 24, 1705. Died March 10, 1709. 1709. Antonio Ibanez de Riva Herrera, Archbishop of Saragossa. Commissioned April 5, 1709. Died September 3, 1710. 1711. Francisco Guidis, Cardinal. Commissioned June 11, 1711. Resigned in 1716. Died October 10, 1725. 1715. Felipe Antonio Gil de Taboada. Commissioned February 28, 1715. Did not serve. 1717 Joseph de Molines, proclaimed January 9, 1717, while in Rome, detained in Milan by the Austrians and died there. Juan de Arzamendi, died without serving. 1720 Diego de Astorga y Cespedes, Bishop of Barcelona, commissioned March 26, 1720, resigned in 1720, died February 9, 1724. 1720 Juan de Camargo, Bishop of Pamplona, commissioned July 18, 1720, died May 24, 1733. 1733 Andres de Orbe y Lateregu, Archbishop of Valencia, commissioned July 28, 1733, died August 4, 1740. 1742 Manuel Isidro Manrique de Lara, Archbishop of Santiago, commissioned January 1, 1742, died January 10, 1746. 1746 Francisco Perez de Prado y Cuesta, Bishop of Teruel, appointed July 26, 1746, commissioned August 22, 1746, died in July 1755. 1755 Manuel Quintano Boniface, Archbishop of Pharsalia, commissioned August 11, 1755, resigned in 1774, died December 18, 1775. 1775 Felipe Bertrand, Bishop of Salamanca, appointed December 27, 1774, commissioned February 27, 1775, took possession May 5, 1775, died November 30, 1783. 1784 Augustin Rubin de Cevallos, Bishop of Jaen, appointed January 23, 1784, commissioned February 17, 1784, took possession June 7, 1784, died February 8, 1793. 1793 Manuel Abad y la Sierra, Archbishop of Salimbria, took possession May 11, 1793, resigned in 1794, died January 12, 1806. 1794 Francisco Antonio de Lorenzana, Archbishop of Toledo, took possession September 12, 1794, resigned in 1797, died April 17, 1804. 1798 Ramon Joseph de Arce y Reynoso, Archbishop of Saragossa, resigned March 22, 1808, died in Paris February 16, 1814. 1814 Xavier Mier y Campillo, Bishop of Almeria, took possession in August 1814. In a series of documents he ceases to appear about June 1818, and for some months the Suprema acts as in a vacancy. 1818 Geronimo Castillon y Salas, Bishop of Tarazona. The earliest document in which I have met his signature is dated October 21, 1818. He had no successor, and died April 20, 1835. End of Appendix 2. Appendix 3 of History of the Inquisition of Spain, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. History of the Inquisition of Spain, Volume 1, by Henry Charles Lee. Appendix 3, Spanish Coinage. The question of values has significance in so many of the operations of the Inquisition that an outline of the successive mintages of Spain becomes almost a necessity. The subject is complicated, after the middle of the 16th century, by the progressive but fluctuating depreciation in the moneda de vellon, or base coinage, which became practically the standard of value in all transactions. The monetary unit of Castile was the maravedi, anciently a gold coin of value, but in the 15th century diminished to a fraction of its former estimation. A declaration of Ferdinand and Isabella in 1503 says that formerly the silver real was equal to 3 maravedis, but now it is worth 34. The unit of weight was the mark, or half-pound, of 8 ounces or 4,608 grains. The intermediate weights were the ochavo of 78 grains, the adarme of 36, and the tomen of 12. These were applicable to all the precious metals but, up to 1731, the mark of gold was reckoned to contain 50 castellanos of 8 tomines, making 4,800 grains, whereby the grain was reduced 1/25. The standard of fineness was fixed, by Ferdinand and Isabella, for gold at 23 3/4 carats, but was reduced by Charles V to 22 carats, at which it remained. For silver the standard maintained since the 14th century was known as 11 dineros 4 granos, pure silver being 12 dineros, equivalent to .925 fine. In 1709 Philip V reduced it to 11 dineros, or .91667, and in some mintages even lower. Gold coins. When Ferdinand and Isabella revised the coinage, in 1497, they ordered the mark to be worked into 65 1/3 excelentes de la Granada. This coin was worth 374 maravedis, and was thus practically the same as the ducat or escado, which was rated at 374. There were also the double alfonse or castellano or peso de oro, equal to 485, the double de la banda to 365, the florin to 265. Thus the ducat, which was the coin most frequently quoted, was equivalent to 11 silver reales. The ratio between gold and silver fluctuated between 7 and 8 to 1. In 1537 Charles V ordered coronas and escudos, 22 carats fine, to be worked 68 to the mark, and to be worth 330 maravedis, which he says was the weight and fineness of the best crowns of Italy and France. With the progressive depreciation in the value of silver, the coinage law of Philip II in 1566 raised the escudo from 330 marks to 400. From 330 maravedis to 400. The old ducats were to be current at 429 maravedis, the castellanos at 544. The tendency of silver continued downward, and in 1609 Philip III permitted the escudo to pass for 440 maravedis, threatening 3 years' exile and a fine of 500 ducats for asking or receiving more. In 1612 he allowed the castellano in bullion to be sold for 576 maravedis, under the same penalties for exceeding it. The escudo or crown remained the standard gold coin. In 1642 it was raised to 550 maravedis, in 1643 to 612, and then reduced to 510, owing to variations in the silver and vellon coinage. In 1651 it is rated at 16 silver reals, in 1652 at 14, in 1686 at 15, but with the new coinage of lighter weight silver it was raised to 19, and the doblon, or piece of 2 escudos, to 40 reals. For larger transactions multiples of the escudo were struck, known as doblones de a dos, de a cuatro, and de a ocho, containing respectively 2, 4, and 8 escudos. The latter, which became popularly known as the Spanish doubloon, were rated in 1726 at 18 pesos, or pieces of 8 silver reals, in 1728 at 16, in 1737 at 15, and in 1779 at 16 again, the doubloon and the peso being virtually of the same weight, each a fraction under an ounce. In 1738, to supply the lack of silver money, there were coined half-crowns of gold, worth in vellon 18 reals 28 maravedis. This fraction was troublesome, and in 1742 the weight was changed to correspond with 20 reales, and the coins became known as ventenos or escuditos. Silver coins. The silver unit was the real, which, under the coinage laws of Ferdinand and Isabella, was worked 67 to the silver mark, of 11 dineros 4 grains fine, .925, worth 34 maravedis. It long continued of this standard, but in the financial mismanagement under Philip IV, the weight was reduced by ordering the mark worked into 83 reals and 1 cartillo, 83 1/4 reals, the old coinage in circulation being advanced 25 per cent. In value by making the peso equivalent to 10 reals instead of 8, but as this failed to afford the expected relief it was suspended in 1643, to be again tried in 1684, when the real was reduced to 84 to the mark, and the old coinage was rated at 10 to 8 of the new. In 1709, we first hear of the peseta, a name applied to the French coin introduced by the War of Secession, rated at 2 reals, and subsequently used to denote the double real of Spanish mintage. At the same time the standard was reduced to 11 dineros or .91667 fine. During the subsequent years of the reign of Philip V, the variations in the silver coinage were numerous and perplexing. The peso, escudo de plata, or piece of 8 reals, was the leading coin, and in 1726 it was ordered that it, whether minted in the Indies or in Spain, should be current for 9 1/2 reals, and, as this did not bring it to an equivalent with gold, in 1728 it was declared equal to 10 reals. This, however, was now confined to the mintage of the Indies, which came to be known as plata nacional. The small coinage of the Spanish mints was termed provincial, and was allowed to remain current at a discount of 20%. It was 77 reals to the mark, and the fineness was only 10 dineros, reduced in 1728 to 9 dineros, 22 grains, or .798 fine, rendering it in reality only about 3/4 the value of the standard. There were thus two entirely distinct silver currencies coexistent, and to these was added a third, popularly known as Marias, plata nueva que vulgarmente se llaman Marias, which was called in by decree of April 27, 1728, but which was still in circulation in 1736. Under these circumstances considerable circumlocution was necessary when quoting sums in silver, to define the exact kind of coin meant, as, for instance, in the coinage law of July 16, 1730, we are told that the allowance for expenses to the official known as the fiel was un real de plata provincial, valor de 16 cuartos de vellon. In fact, as we shall see, the debased coinage known as vellon had become the real standard of financial transactions. In the later periods it will simplify the appreciation of amounts recorded to remind the reader that the peso, or piece of 8 reals, is the modern dollar, and the real, or 1/8 of this, is the coin familiarly known of old in various parts of the United States as the bit, the 11-penny bit, shortened to levy, the 9 pence, or the shilling. The maraveda was 1/34 of this, or about 3/8 of 1 cent. In the colonies there is frequent allusion to the peso ensayado as distinguished from the peso de a ocho, which I gather to be a piece worth 400 maravedas, or nearly 11 3/4 reals, a little more than a ducat. Vellon coinage. The debased coinage known as vellon was an alloy of silver arid copper, which proved the source of unutterable confusion in Spanish finance. As we find it prescribed by Ferdinand and Isabella in 1497, it is merely a token coin convenient for small transaction, consisting of 7 grains of silver to the mark of copper, worked into 192 blancas, the blanca being 1/2 of the maravedi. Complaints were made that it was exported at a profit, so that it became scarce, and in 1552, Charles V, to remedy this, reduced the silver to 5 grains. The extravagant expenditures of Philip II rendered him eager to clutch at any expedient to relieve immediate necessities, and in 1566 he adopted the unfortunate device of issuing a moneda de vellon rica, with 2 1/2 dineros, 2 grains, 98 grains of silver to the mark of copper, to be worked into cuartillos, 80 to the mark, worth 1/4 real or 8 1/2 maravedis, into cuartos, 170 to the mark, worth 4 maravedis, and medios cuartos, 340 to the mark, worth 2 maravedis. The blancas, or half maravedis, were retained, but the silver in them was reduced to 4 grains to the mark, worked into 220 pieces. Although there do not appear ever to have been larger coins of vellon issued than those authorized by Philip II, the flood of this inferior money supplanted the precious metals. It became the basis of all internal transactions, and the precious metals were reduced virtually to the position of commodities. There was a restamping of this coinage in 1602, in which the silver was omitted, put into forced circulation at a value of 7 to 2. With all the power of Spain, backed by the treasures of the New World and wielded by an autocratic monarchy, it was impossible to maintain so vicious and artificial a currency at par, and there followed, during the 17th century, a series of the most desperate attempts to remedy the evils which were crippling the commerce and industry of the nation. In 1619 there was a solemn promise made that no more of the pernicious stuff should be issued for 20 years, a promise only made to be broken, and renewed in 1632. In 1625, under the severest penalties, the premium on gold and silver was limited to 10%, and in 1628 the nominal value was reduced one-half, but in 1636 the permissible premium on silver was recognized as 25%, immediately after which the vellon coinage was restamped and trebled in value. In 1640 the premium was allowed to be 28%, and in 1641 there was another restamping and the value was doubled, followed by recognizing the premium as 50%. In some accounts before me of the salaries and expenses of the Supreme Council of the Inquisition, not dated, but evidently belonging to this period, the figures set down are increased when added, in one case by 28%, and in another by 50%, to adjust them to the currency in which they were expected to be paid. In other statements some items are specified as payable in vellon and others in plata. In the effort to bring the vellon to par in 1642, it was suddenly reduced to 1/6 of its current value, and then, in 1643, it was raised fourfold. This resulted, in 1647, in a premium of 25%, but when, in 1651, it was again restamped and restored to the value which it bore prior to 1642, the premium rose to 50%. In June 1652, another attempt was made to reduce it to 1/4, but this seems to have been a failure, and in November the edict was suspended. In 1660 its further issue was suspended, and the experiment was again tried of an alloy containing 20 grains of silver to the mark, or about 1/230, which became known as the moneda de molino de vellon ligado. This was so unsuccessful that in 1664 its nominal value was reduced to one-half, and all other vellon currency was prohibited, while in February 1680 a still further reduction of 75% in its value was ordered, and in May its use was forbidden. It was declared to have no value as currency, and the premium of 50% was permitted as against other vellon coins, which had still continued in circulation. This lasted for 4 years, when in 1684 the moneda de molino was restored to circulation with a nominal value double that of the last reduction. With the 18th century the pretence of alloying copper with a fraction of silver was abandoned. In 1718 a pure copper coinage was issued, and by this time the premium on specie recognized by law had advanced to nearly 100%. In spite of the prohibition to ask or receive more than this, people were forced to pay more. Traders kept the copper coinage tied up in bags representing the larger coins, and refused to furnish the latter except at an advance. The premium gradually rose, until, in 1737, the Real de Plata Provincial was recognized legally as worth 2 reals de vellon, and the Real Plata Nacional as worth 2.5. Although there were no coined reals de vellon, they were the standard money of account on which all transactions were based. In the laws regulating the mints the salaries of the officials are always stated in vellon. Thus in 1718 the superintendent of the Mint of Madrid has 24,000 reals de vellon, the treasurer 16,000, and so forth. In 1728 the superintendent is allowed 500 escudos de vellon, the contador 400, etc. In 1730 it is provided that the sum of 120,000 reals de vellon is to be placed in the hands of the treasurer for current expenses, and he is to give in security 20,000 ducados de vellon on unencumbered real estate. From this it follows that, when the kind of coin is not specified, there may be some difficulty in estimating the value of a sum of money mentioned. The difference between silver and vellon went on increasing. In 1772, when a new coinage of gold and silver was issued, the gold escudo, worth 16 reals de plata, was declared to be worth 37.5 reals de vellon. With the Revolution the old coinage passed away and was replaced by the decimal system, the peseta and centimo being equivalent to the French franc and centime. Yet prices continue to be quoted in reals, which are now rated at 25 centimos, or about 5 cents of American money. Nothing is more difficult than to ascertain accurately the variation in the purchasing power of money, but perhaps the price of labor affords the most trustworthy standard. In the 15th century this would seem to have been about 6 maravedis a day. In the 18th, common laborers employed in the mints received 3.5 reals de vellon per diem, while those in more confidential positions, such as watchmen, were paid 6. As a matter of course, the kingdoms of the Crown of Aragon had their independent systems of coinage, which were based on the old divisions of the mark, almost everywhere prevalent, of libras, sueldos, and dineros, or pounds, shilling, and pence, there being 20 sueldos to the libra, and 12 dineros to the sueldo. In the documents of the early period there are frequent fluctuations in the relations between these coins and the Castilian system, but as a rule there were reckoned 20 Aragonese sueldos to the ducat, which therefore was equivalent to the libra. In Catalonia the sueldo barcelonese was 24 to the ducat, and there was also a coin known as morabatin, equal to 9 sueldos. Unification of currency throughout the monarchy was a desirable object, long frustrated by the stubborn particularism of the provinces. It was especially difficult to bring about in Catalonia, where the vellon coinage had been largely diluted by the allies during their long occupation of the principality in the War of Succession. An edict of 1733 informs us that there were 24 dineros to the Catalan real, but most of those in circulation of the coinage of 1653 had been restamped by the allies to double their nominal value. They had also coined dinerios catalanes, with the same alloy of silver as the mintage of 1653, but with only half the weight, yet circulated at the full value. The edict denounces the dinerios of both Aragon and Catalonia as an intolerable abuse, and with superfluous emphasis orders that their use be abandoned immediately in Aragon and Catalonia as soon as sufficient money of vellon can be coined to take their place. The effect was futile, for another edict of 1737 assimilates the dinerillo of Aragon and Valencia to the Castilian ochavo, or piece of 2 maravedis, and the dinerillo of Catalonia to 1 maravedi. In 1743, in consequence of disputes arising between troops quartered in Catalonia and the peasants, it was ordered that the vellon money of Castile should circulate freely in Aragon, Catalonia, and Majorca. As late as 1772, an edict calls in the local small coinage of Valencia and orders it replaced with Castilian money, but this was so unsuccessful that it was followed, in 1777, with one confining the use of these coins to Valencia and forbidding their circulation elsewhere. When the unification of the currency occurred does not clearly appear, but it probably was not until the revision of the monetary system in the present century. The old cruzado of Portugal, to which reference sometimes occurs, was virtually the same as the Spanish ducat. End of Appendix 3.